Good morning, ladies and gentlemen. I thank all of you for coming today for our discussion, and I'm happy to welcome you to our first academic session of this conference focusing on sanctions, business, and human rights. Yesterday, we had a great discussion at the level of the higher-level segment, as well as the discussion with humanitarian actors, and I hope that our discussion with lawyers, with scholars, will be not less interesting, and it will allow us to address the new perspective of the problems. I need to say that currently there are quite a lot of international conferences which have the term sanctions in their title. At the same time, unfortunately, the majority of these conferences are very limited as concern their participants, and they include only mostly the scholars coming from the countries which impose sanctions. These conferences discuss the issues how to make sanctions more effective, or how to impose secondary sanctions demonstrating their legitimacy. And I believe it's a fully wrong approach. We need to discuss the legality of the use of any type of unilateral activity, looking at the root causes of the problem. We need to assess what measures can be taken to ensure that from the perspective of law, there will be mechanisms of the access to meaningful remedy, to the access to restitution, accountability, and responsibility and redress. And moreover, I believe that discussing this situation only among one group of scholars, one group of states, is not a way to find a solution. We need to bring together people from different geographic regions. We need to bring together people from countries which impose sanctions and countries which are under sanctions, because I believe that law, and in particular international law, is the universal language. In the world which has been established by the Charter of the United Nations, international law shall be all the same for all countries, as soon as it's built up on the principle of sovereign equality of states and the principle of promotion and protection of human rights. I'm very grateful today for all our keynote speakers who agreed to come and to discuss the problem from the perspective of international law, international relations, and a few other conjunct areas to address the root causes, to address the legality, to identify the challenges, and at the very way to look for the ways out of this situation. I'm also very happy if our keynote speakers, as well as all other participants, will address the document which has been developed by the mandate, the guiding principles, and the commentary to the guiding principles. The purpose of the guiding principles was not to create new legal norms. I'm just an academic, and even as a mandate holder, I'm not entitled to establish new legal norms. But at the same time, what I can do, I can identify what existing treaty and customary international legal norms shall be applicable in the specific situation to be able to resist the use of unilateral coercive measures in the world, means of their enforcement, and how they can be used to minimize overcompliance. To avoid this situation when sanctioning states which implement sanctions, as well as businesses, are shifting responsibility to each other, and at the very end, no one is responsible. However, human rights are violated very broadly, and these people, especially those who have never been directly designated, have no way out. No access to justice, no access to the meaningful remedy. And at this very end, they become desperate, not knowing what exactly shall be done. So therefore, I'm welcoming all your comments on the guiding principles, on the commentary. I'm welcoming your proposals, because naturally, I'm absolutely sure that I definitely missed something. I did my best, but I'm sure that there could be a valuable contribution there, and the document can still be approved. The purpose of the document was to establish a sort of the instrument, the collection of authorities to give an instrument to states, to businesses, organizations who intend to protect human rights, and those affected by human rights violations due to the use of unilateral sanctions, means of the enforcement and overcompliance, how they can protect their rights. And what are the legal authorities they can use to protect their rights and to bring international law back to the international stage. Take into account that we have the list of keynote speakers, and I would appreciate, especially take into account that I already received a very long list of those who want to take the floor from the ground, if our keynote speakers will limit themselves to 10 to 12 minutes within their presentation. Again, for those who want to take the floor from the ground, I would really appreciate if you stay focused on the topic of our discussion, and especially take into account that we have 2 sessions. And the sessions are different a bit as concern the focus of the sessions. I would appreciate if those who already identified their willingness to take the floor, which session they want to take the floor at. Moreover, I'm also reminding that as soon as it's an academic discussion, it's possible to take the floor not only to present your position, it's possible to take the floor to ask questions to our keynote speakers. And what I plan to do, I plan to leave a bit of time at the very end to provide all of them with the possibility to respond to your questions. And I believe that is one of the huge benefits of academic conferences, when it's possible to ask questions and to receive answers. Again, from the technical perspective, I'm informing you that in around an hour and a half, there will be coffee available outside. So everyone who will be in need to get a cup of coffee will be very much welcome to do so. I believe, I do not know whether I shall make a formal break for 5 minutes. So it looks like we need to have, like people say yes. So we will make a formal break for 5 minutes after the presentations of the keynote speakers, and then we'll continue with the discussions so that people can pick up a cup of coffee. And without further delay, we are starting our academic segment of the conference, and I'm happy to give the floor to, apologies. I need first, before we start, I need to mention that many of the keynote speakers, as well as many of those who registered and participate online, either shared their contributions for development of the guiding principles or participated in expert consultations. And I cannot miss the opportunity to thank all of them, especially those who participated in final drafting of the guiding principles, because they assisted a lot. And they help to format the document in the way you see right now. And right now, without further delay, I'm happy to give the floor to Professor Mohamed Abdelmonaim, the member of the UN Committee on Economic, Social, and Cultural Rights, and member of its working group on individual communications, with the topic Culture of Punishment, Sanctions, Unilateral Coercive Measures, and the International System. Professor, the floor is yours.
Thank you. Good morning, everybody. I also wholeheartedly hope that the guiding principles will be adopted, applied with the conviction that they are law, with consistent practice that one day they'll become legally binding. I'll divide my talk briefly into 3 parts. First part is how is the problem, how I see the problem now. Second part, what's the diagnosis of the current situation? And third part is what to do to overcome this. First, before coming to this meeting 3 weeks ago, I was looking for sources of inspiration, and I have looked into Dostoevsky, famous novel, Crime and Punishment. He started writing it exactly this month, November, about 67 years ago. The story is about Rodion Raskolnikov, Raskolnikov, who killed an elderly woman, Alyona Ivanova, for the purpose of robbery, for her money, and eventually killing her sister, Lisa Vita Ivanova. It was made into many, many movies. You can look at it if you don't have time to look at the novel. I was wondering if Dostoevsky was writing his novel today, what would he have said about sanctions and these coercive measures? Because when you read about crime and punishment, crime happens so often, but it is not a rule in life. Punishment happens and happens so often, but it is not a rule in life. They are likely to be exceptions, not rules. The rules are normal living without crimes and without punishments. And these are marginal, at least in terms of quantity. And when you look at the situation today, there are two norms concerning punishment. The first thing is that there shall be no punishment without a crime already committed. The second is that the punishment has to be proportionate to crime. But this is not what is happening indeed. If you look around you, you'll find how many crimes, even genocide, even crimes against humanity, are viciously committed with no punishment at all, even conceding to the crimes. And you'll find how things are disproportionate. So you have punishment without crimes, and you have crimes without punishment. This is the situation. But why is that? Because we moved from the exception of crime, from the exception of punishment, into a culture of punishment. It became a culture. And when the culture of punishment is there, then there is a multiplication of crimes. Sometimes when you are punishing somebody, you are committing a crime. And you are not even accountable for it. And this culture of punishment on the part of some nations have led to a culture of fear on the part of others. So when you eat, you have food for you. So people tell you, eat as much as you can, because one day you never know if sanctions will come and you will starve. When you have internet, connect to your loved ones, because one day you will be cut from that and you will not be connected to them. When you have money in the bank, you consider taking as much as you take, because maybe the bank will be under targeted sanctions and you will lose your money. A culture of fear and a culture of punishment. Very miserable condition for the international community indeed. Why is it there? I don't tend to define a strict line of distinction between what is unilateral coercive measures and Security Council sanctions. Because according to some sources which I read, about 75 to 80% of unilateral coercive measures are performed in support of Security Council sanctions. In a way, they provide a sort of umbrella, contrary to what is said in the Charter, what's thought in the Charter, but I'll refer to that later. And even the worst of consequences of sanctions are not usually and only the ones coming from unilateral coercive measures. Some of Security Council sanctions had devastating and even more devastating consequences. And if you recall the situation, then you know where and why. In one case, 30,000 babies, not just grown-up children, 30,000 babies were lost because of sanctions. So the second point now, the cause. What is the crux of the matter is what? I want to refer to Article 41 in the UN Charter. Please show Article 41. Yes, here we have the article. Look at 41 first and contemplate carefully. How is it written? I read, the Security Council may decide what measures not involving the use of armed force are to be employed to give effect to its decisions. Okay. And it may call upon the members of the United Nations to apply such measures. This is the chapeau. Look at what is coming after. These may include complete or partial interruption of economic relations and of rail, sea, air, postal, telegraphic, radio, and other means of communication, and the severance of diplomatic relations. When you contemplate this may include, so this list, however severe if applied, is not exhaustive. They may include, that is, the Security Council may contemplate other measures beyond these. And here it is, an excessive discretion to the Security Council. Look at Article 42. Actually, here they are taking a lot from the experience of the League of Nations, so they tend to compensate for what they call failure of the United Nations, of the League of Nations. Article 42, should the Security Council consider that measures provided for in Article 41, that's say sanctions, would be inadequate or have proved to be inadequate? Look at the tricky formulation. Would be inadequate or have proved to be inadequate. And who's going to determine that? Of course, Security Council. It may take such action, and such means that the list is not exhaustive. They can invent actions which are not here in Article 41. Would be inadequate or have proved to be inadequate, it may take such action by air, sea, land forces as may be necessary to maintain or restore international peace and security. As may be necessary, and from the standpoint of who? Only the Security Council. Look at all that, actually. It's really the problem is here. The problem is in Article 41 and subsequently in Article 42. And the Charter meant to establish a sort of sequence between Article 41 and 42, but the way both are written, it distorted even the link between the two articles. This has to be addressed. And here I come to the third thing, what to do. The only thing is to reconsider many things in the Charter, feasible or not feasible. But there must be a start somewhere. Something has to be launched. Unless there is an overall reform of the UN system, the problem we are going to live with, and for long. and even worse. Let's just be realistic. I think that the situation is that we have to put an end, and the international community has to strive to put an end to this kind of system. Have you ever heard about a punishment in any municipal law in the world where a police station decides for the punishment? The law is there, but there must be a judge who decides. And you have the right to appeal, even if a judge decides, which means some linkage has to be made to two organs. One is the General Assembly. It shouldn't be the custody of the Security Council. Practically 15 out of all this vast membership of the United Nations, and within the 15, 5, the authority, such a big authority, is given only to something like 2% of the whole membership of the United Nations. It's incredible. Only 2%. And within the 2%, you have one who could stop anything. And here you have the situation, crime without punishment and punishment without crime. So there must be a linkage in the designation, the implementation of sanctions to, on the one hand, the General Assembly, on the other hand, the International Court of Justice. As I started with Dostoevsky, crime and punishment, I must say, if you don't have time to read it, please look at the movies before or after your dinner today. There are at least 15 movies done about the sort of interpretation of the novel Crime and Punishment. You will find good names like Woody Allen and Vanessa Redgrave, and why it is worth seeing, and reading, because you will find many similarities between the characters of the Dostoevsky novel and the actors involved in sanctions today. And you will realize that the international environment today is not that much different from the one that Dostoevsky described in his Crime and Punishment. In spite of good things that we have in the international system, but it is still ravaged with hate, disdain, corruption, and prostitution, even international. Thank you for your attention.
Thank you very much, Professor Abdelmonem. Indeed, a very good beginning with reference to the classics of the literature. With all that in mind, I'm happy to give the floor to our next speaker, His Excellency Mr. William Castillo, the Vice Minister of Anti-Blockade Policies of the Bolivarian Republic of Venezuela, who will present by video on the methodologies for recording unilateral coercive measures and the impacts, the experience of the Anti-Blockade Observatory of the Bolivarian Republic of Venezuela. And let's have the video.
Morning. On behalf of the Bolivarian Republic of Venezuela and President Nicolás Maduro, re-elected by Venezuelan people on past July 28, I thank Her Excellency, Dr. Elena Duhan, for convening this important event. Venezuela agrees with the objective that brings us together today, adding knowledge and generate an international doctrine that strengthens the fight against unilateral coercive measures imposed on sovereign states outside international law and the United Nations Charter. Unilateral sanctions are a global problem that affects 30 nations. When deepened and extended over time, severely affect human rights, access to conditions to life, and can be considered according to Rome Statute crimes against humanity. Since 2014, the Bolivarian Republic of Venezuela has been victim of an aggressive policy of unilateral sanctions and economic punishment, mainly by United States, with support of European Union, other nations, and international financial system. These measures impose hard conditions, hard restrictions on the oil industry, public finance, and foreign trade, including access to food, medicines, and basic supplies. Even during COVID pandemic, sanctions restricted Venezuela's access to vaccine, treatment, and NAS. Such restrictions also include actions against private companies and national and foreign individuals, travel bans, visa refusal, freezing assets, and international funds in the financial system. In 2020, Venezuela approved a law to address economic, social, and humanitarian causes by UCMs. The constitutional anti-blockade law for national development and guarantee of human rights is the pivot in Venezuela legislation to fight against sanctions. This innovative law seeks to defend population, economy, and Venezuela access public institutions, persons, and companies from UCMs. The law creates an international product investment center that offers guarantee to domestic and foreign investors, an observatory of coercive measures who obfuscate its record the process and contribute design of policy that allow the country to overcome the UCMs. This legal instrument establishes the null and unlawful nature of unilateral coercive measures against Venezuela, Article 6, incorporates United Nations resolution that establishes the illegality of any sanction that is not approved by UN Security Council. Sanction and other restrictive or punitive measures constitute threats to national security under Venezuela Constitution. In Article 4, the anti-blockade law, Venezuela incorporates two main categories. First, unilateral coercive measures equivalent to unilateral sanctions or direct sanctions to Venezuela state, person, or entities. Second, restrictive or punitive measure refers to any indirect action to restrict rights to Venezuelan state, including person or company. In 10 years, Venezuela has registered 947 UCMs and other restrictive measures. Let me briefly mention some findings. Estimated cost of losses between 2016 and 2022 among $642 billion. Total loss of oil industry around 3,993 million barrels of oil, which became into a loss of $232 billion. Other $22 billion in cash and Venezuela assets are currently blocked or frozen in international financial system. Venezuela lost 90% of foreign currency income in 8 years. In 2017, sovereign and PDVSA debt was blocked and the country defaulted. Due to overcompliance, Venezuela was expelled from SWIFT system banking. This was followed by recession that reduced the gross domestic product of 1/5 of its value. Up to 41 banks around the world frozen Venezuela taxation, including food and medicine imports. Economic impacts quickly shifted to the public budget, social program, and public service. Between 2016 and 2017, was blocked in 4 of vaccine and medicines, which raised the prevalence rate of some disease at least 3 years. Overcompliance reduced up to 60% local production of medicine, and many pharmaceutical companies stopped sending their product to Venezuela for fear to sanction. There was an unprecedented migration wave that affected broad professional sectors, particularly in health, education, engineering, and specialized technicians. In some medical areas, Venezuela lost half of its specialists. Venezuela's main access road, Citgo Corp, blocked by executive order from Donald Trump in 2019, is about to be actioned by US court. Venezuela has also had 32 metric tons of gold frozen at the Bank of England. This gold is part of our international reserve. Next December, Venezuela will complete a decade under unilateral coercive measures. This policy includes 2 Congress acts. Oh, sorry. Just a few hours ago, the US Congress passed a new law that blocks trade between the US company and Venezuela government. It's absolutely insane. There are also 7 executive orders against Venezuela administrative and judicial measures, lists of person, entity, and access sanctioning a large number of punitive measures. This has been done under the excuse of defending democracy, invoking unilateral sanctions and political dissension, such as not recognizing the legitimate government of Venezuela. This president of Venezuela is Nicolás Maduro Moros, the only president of Venezuela. The Bolivarian Republic of Venezuela has responded to this unilateral policy with instruments of international law, developing an anti-sanction legislation and with economic policy that have allowed the country adapt to the sanctions and have produced, after COVID pandemic, 4 consecutive years of economic growth. Venezuela has denounced before the Human Rights Council the impact of sanctions and overcompliance on public service, business, companies, and the human rights of the Venezuelan population, and demands a strong and more committed multilateral action than simple appeals. The Bolivarian Republic of Venezuela has gone to International Criminal Court to denounce the sanctioning official for crimes against humanity. Venezuela does not use counter-sanction or any retaliatory measures against sanctioning the state, but has some mechanisms bypass them using our legitimate economic rights. Paradoxically, using mechanisms to carry out commercial and financial operations to which Venezuela is entitled is also considered a violation of the sanctions. Individuals and companies that those who are prosecuted in USA and other countries. 70% of the measures issued against the country have been directed towards private sector. We highly value work carried out by the Special Rapporteur on the UN, Her Excellency Elena Duhan. We also highlight incessant activity of Group of Friends of the UN Charter, which after 14 years succeed in bringing this issue back to the debate in General Assembly. Venezuela reforms need an urgency that the UN develop a common methodology of analysis and share doctrinal principles that establish illegal nature and condemn sanctions as an instrument of foreign policy. Venezuela hopes the academic research and body doctrine can be consolidated to enable sovereign states to understand and fight against this illegal instrument. At the same time, we warn that such principles should not be interpreted as instruments for normalization of sanctions through a false disjunction between good sanctions and bad sanctions. Unilateral sanctions and overcompliance affect the global economy and human rights of 1/3 of the world population and threats world peace and security. Concrete steps must be taken to stop this insensibly and absurd and cruel policy. On this path of law and international justice, you will always find the Bolivarian Republic of Venezuela. Thank you very much.
Thank you very much for presentation. Indeed, the observatory developed by Venezuela is among a very few. I eventually know only 2, the one done by Venezuela and one done by Cuba, mechanism for monitoring and assessment of the impact of unilateral sanctions. Beside the monitoring instrument I tried to establish as a universal one, but I need to say that I learned a lot from both the Venezuelan and Cuban examples. Just a small announcement. as I mentioned yesterday, upon the recommendations which I received from non-governmental representatives, I drafted a list of recommendations, and it's open for signature for humanitarian actors, for scholars, for lawyers, as well as for other non-governmental participants. So we printed a sufficient number of copies. When we will have the coffee break, I welcome all of you to pick one and to sign if you're ready to sign. I understand that for some people it might be, let's say, might raise some concerns. And if you want to keep your signature confidential, it's also possible to identify that you are signing, but you are not ready to go public. So it's also an option. We will put it online in the nearest future as well, and it will be on the webpage of the conference as well. And now I'm very glad to give the floor to Professor Cecilia Baylet, the UN's independent expert on human rights and international solidarity, who is a professor at the law faculty of the University of Oslo, who will present the topic of international solidarity and the principle of proportionality in relation to unilateral coercive measures. Please, Cecilia, the floor is yours.
Thank you, Elena. I have been very inspired by the sessions I've attended on the humanitarian actors. It was illuminating to see their profound knowledge of the impact of the consequences of the failure to take proportionality analysis. So I'm here to explain a little bit how we can incorporate those perspectives to improve the system. The use of unilateral coercive sanctions without authorization of the UN Security Council has received due criticism due to concerns about the high risk of ineffectiveness in aim, disproportional humanitarian consequences, infringement on the right to sustainable development, and counterproductiveness in supporting democratic evolution. So according to the rules of state responsibility and customary international law, states can impose unilateral sanctions as countermeasures to wrongful acts in international law, but they are absolutely required to abide by necessity, proportionality, and non-discrimination norms, as well as human rights. So the revised draft declaration on international solidarity sets forth as an objective to create an enabling environment for combating unilateral coercive measures that are inappropriately or too broadly targeted. This standard infers a proportionality standard. Proportionality refers to the relationship between the means and the ends, that's suitability, and the imperative to use the least intrusive measures, avoiding excess. It is considered to have the status of customary international law that has its roots in the principles of equity and humanity. And as defined by Crawford, proportionality sets forth that a state's acts must be a rational and reasonable exercise of means towards achieving a permissible goal without unduly encroaching on protected rights of either the individual or another state. So within public international law, the use of sanctions must be proportional to the threat to international peace and security. And Hofer explains that a proportionality analysis would include balancing the interests of the initiator of the sanctions, such as responding to serious violations of human rights, and the interests of the affected population, for example, in enjoying an adequate standard of living without excessive limitation, along with the suitability or appropriateness and necessity of the sanctions in achieving the goal of the initiator. So Goodman concurs that the proportionality evaluation calls for empirical insights about the relationship between economic sanctions and human rights. But he actually argues that the necessity prong of the analysis is most relevant since human rights improvements are unlikely to be attained through sanctions. So unilateral economic sanctions, including comprehensive as well as sectoral or targeted sanctions, are often characterized as carrying a high risk of disproportionality, given that civil society often is exposed to humanitarian crises, in which the standard of living is significantly reduced, including the lack of access to food or medicine as a consequence of the measures taken that affect the imports. So should sanctions be considered disproportional, states should consider alternative means that would be less intrusive on human rights, such as offering incentives via diplomacy. And every one of the cases brought up yesterday should be explored in terms of discussing to what extent we can create negotiation strategies as an alternative. It is suggested that states and UN apply a review process to measure proportionality by regularly assessing the threat and the humanitarian impact of proposed sanctions, because this should happen before the sanctions are applied. If you wait till after the sanctions are applied and try to bring it to courts, the courts will often defer to what's called a political question exception, that they won't review it because of the deference to the executive. And this process should look at setting up step-by-step timetables for achieving the purposes. So the famous paper by Mark Busiet proposed a 6-pronged test that includes suitability, necessity, and proportionality as criteria. So he asked, are the sanctions imposed for valid reasons instead of politics? It should be related to peace and security. Do they target the relevant parties and not have collateral damage to third parties, states, or peoples? Do they target relevant goods and not interfere with humanitarian goods? Are they reasonably time limited? They could become illegal if they extend for too long. Are they effective? And do we see a response from other governments or intergovernmental bodies and NGOs to the violations relating to the sanctions? So we've seen that disproportional unilateral coercive measures often fail to change in authoritarian governments' repression of human rights, because the government then refers to humanitarian consequences of the external measures as grounds for maintaining its stronghold against foreign intervention. So instead of reducing human rights violations, unilateral coercive measures actually worsen the suffering of the civilian population, in contradiction of Articles 50 and 51 of the International Law Commission's Articles on State Responsibility. Yesterday, one of the NGOs said that they violate the principle of humanity. And this is something that shows the urgency of reviewing the system. So the most important example, also cited yesterday by an NGO, was the response of the UN General Assembly issuing 32 resolutions calling for an end to the sanctions in Cuba. And these types of votes are pointing to an emerging rule of customary international law that recognize the restriction of unilateral coercive measures which violate proportionality. In 2021, the US Department of Treasury issued a Treasury sanctions review that actually recognized the aim of minimizing unintended impacts and reversing sanctions where possible. So this is an important source of reference. So they call for a clear policy objective that should be part of a larger strategy beyond sanctions, and an assessment using a rigorous economic analysis with technical expertise and intelligence to ensure that sanctions are actually the right tool, and looking at multinational coordination to review, and have a stakeholder consultation to see if the sanctions actually have to be reversed. So I suggest that there's a need to promote an international solidarity plan to form partnerships with state institutions, civil society, corporations, faith groups, to pursue sustainable development as a way forward from the current stagnated adherence to a failed unilateral sanctions policy that worsens a persistent humanitarian crisis, choosing instead to place respect for the principle of proportionality as the center of identifying alternative diplomatic solutions. So an element of the proportionality analysis would include the analysis of the risk of overcompliance that the UN Special Rapporteur on UCMs has pointed out. And later this afternoon, you will hear from Joy Gordon. She writes about overcompliance with US sanctions on Cuba negatively affecting its trade with private actors, including banks of third countries, due to the ambiguity of the regulations that require due diligence without defining what is due diligence, as well as the risk of severe financial penalties and denial of access to the US financial system. So as a result of overcompliance, the remittances from abroad are blocked and exports are limited and tourism is severely reduced. The transport of food, medicine, fertilizers, seeds, and provision of services is rendered absolutely impossible, bringing the country to the brink of complete state failure. So there are currently these normative initiatives that include proportionality as an element of evaluation of the scope of sanctions. So these draft guiding principles on sanctions, business, and human rights from 2024 recognize directly the principle of proportionality, linking it to the obligation to avoid overcompliance. So paragraph 15.3 states any means of pressure taken by states or international organizations in the course of countermeasures against other subjects of international law shall be performed in full compliance with the standards of law of international responsibility and must be proportionate to the injury suffered, taking into account the gravity of internationally wrongful acts and the rights in question, being limited to non-performance for the time being of the international obligations with no effect to the obligations of due protection for human rights. And there's also out there an alternative model humanitarian checklist for sanctions unit that you can find online. And this one calls for identification of the risk of overcompliance and its impact on vulnerable groups. It states, consider ways in which unintended consequences of overcompliance and de-risking may be impacting disproportionately on underrepresented groups, including women and girls. So these soft law instruments are positive effects to evolve better policies and practices to ensure the primacy of human rights as a center focus for policymakers at present and in the future. And I look forward to seeing the development and the application of the norms presented here today by my colleague. Thank you very much.
Thank you very much, Cecilia. Listening to you, I just realized that I need to address this issue not only within the scope of assess and countermeasures, but also within the scope of the principle of humanitarian precaution. I try to introduce in the guiding principles, and therefore, if you would have some proposals and comments to the commentary, they're very much more than welcomed. So thank you very much. And now I'm giving the floor to Professor Antonios Zanakopoulos, Professor of Public International Law at the Faculty of Law of the University of Oxford and Fellow in Law at St. Anne's College, with the topic, the law of coercion in the international legal order. So Antonios, the floor is yours.
Thank you very much, Elena, for the invitation. The role of coercion. So here's what I'm going to try to do, and I'm going to try to take this back to basics to provide a kind of framework that I think is helpful and which also underlines the challenges facing the Special Rapporteur in her work, because coercion as a concept is very, very fundamental in the law. And we've already, this morning, and I imagine yesterday, I'm sorry I couldn't be here yesterday, but also in academic discussions and in policy discussions that have been present, you get this word salad where everybody comes out and says, oh, economic coercion this, unilateral coercive measure that, countermeasures the other, sanctions the third. And nobody actually takes the time to organize those terms, to define what they mean, and to try and understand how they actually work. So if you permit me to take this back to basics a little bit and stress how fundamental coercion is in the law, because it is definitional. Laws are supposed to be coercive systems for the regulations of relations. So coercion is a definitional element in the law. There needs to be some sort of coercive process in the context of regulating behavior. So starting with that, we can easily see that the definition of a rule, for example, is a command that is backed by a consequence, but the definition of a legal rule is a command that is backed by a coercive consequence. So something coercive is happening. In the domestic legal orders, which are highly centralized, coercion is applied by one entity, by the executive, right? The power of the coercive power has been centralized to one entity so that individual participants in the system don't actually have coercive powers. International law is decentralized. It's a decentralized legal order. This means that there is no collective entity, no single organ that is actually there to apply coercive consequences. This means that coercive consequences are left to states to apply unilaterally and at their own risk. The violations of international law that happen can only be addressed unilaterally by the state that has been injured by the breach through the adoption of countermeasures, which are definitionally coercive. They are also allowed. Shocker. Second shocker. A countermeasure is a breach in response to a breach. So a breach of international law is contained within the definition of a countermeasure. If state A violates the law against state B can violate the law against state A until state A seizes its violation, offers reparation, and so on and so forth. However, all sorts of unilateral measures taken by states do not actually, in and of themselves, violate international law, or at least violate some sort of obligation that we can point to. This is a huge area of the law. Quite a lot of it is contained in discussions of sanctions or unilateral coercive measures or concepts of economic coercion or whatnot. But in reality, these are perfectly allowed by the law. This is what we call retortion. Let me give you some examples. I mean, the easiest example, which I'm sure you're all aware of, is breaking off diplomatic relations. Oh, you did something that I don't like. I'm breaking off diplomatic relations with you. Is this coercive? In an everyday sense of the word, it might be. You're applying pressure on someone simply because you don't like them. You're breaking off diplomatic relations with them. But international law does not require you to maintain diplomatic relations with anyone. You can break them off at any time and for whatever reason. And so this is an unfriendly but perfectly lawful act. The system allows it. Another example. Oh, you voted for the communists. I don't like the communists. I now stop giving you voluntary aid. If aid was voluntary, there is no obligation to keep giving it. You are violating no rule of international law by stopping voluntary aid. Oh, but you're doing it because you don't like the communists. Okay, it doesn't matter. International law does not prohibit it. Oh, I will no longer have voluntary trade relations with you. If there's no obligation to maintain trade relations with someone, you can break them off at whatever point. Now, you can call it a blockade, you can call it this, you can call it that, you can call it the other thing, but what it is a measure of retortion, an unfriendly but perfectly lawful act. Now, why am I saying all these things? I'm saying all these things because I need to highlight the difficulty in understanding what unilateral coercive measures mean or what the concept of economic coercion means, right? Economic coercion, in fact, is mostly allowed by international law. There are limitations, and I will come to those, but mostly it is allowed in international law. It is either allowed as a countermeasure, as a violation in response to a violation, so as a method of enforcing the law, or it is allowed simply because there are no rules prohibiting it when it comes to voluntary aid, voluntary trade relations, and so on and so forth. This is a feature of the system. It's not a bug. It is created this way. And in a way, it is very, very similar to what happens in domestic law as well, in the sense that, you know, whenever you hear the word freedom, run for cover. Whenever I hear anybody talking about freedom, I run for cover because I'm sure it's not freedom for me, it's for somebody else. So all subjects of the law are equal, right? As we all know, and they freely meet in the market on equal terms to contract. So you're absolutely free to accept the job that is being offered to you by the employer, or you are free not to accept it and, I don't know, die of hunger, right? Is there no economic coercion there? Of course there is. But it's economic coercion that is built into the system. In the final analysis, this is how capitalism works. And we all sort of like appear to be shocked that somehow this is then translated into the law and how the law works. Now, I don't want to leave you on completely sort of like a downbeat note. There are certain limitations. There are limitations on taking countermeasures, and we've heard some of them. Cecilia referred to some of them, proportionality among them, and sort of limitations with respect to the types of rules that we can violate when taking countermeasures. So, for example, you can't violate human rights, you can't violate the prohibition of the use of force, and so on and so forth. There are other limitations whenever unilateral sanctions are being applied. These countermeasures are being applied. Limitations under the law of jurisdiction. So there's lots of work on that in the principles, exorbitant assertions of jurisdiction in the case of secondary sanctions, ability to respond to those by adopting blocking statutes. We've already heard some of these things today. But what I would like you to keep in mind, sort of like understanding the challenge that we're facing here, is that these are all what I call rearguard actions. There are sort of like attempts to use the law, as we should, to sort of like stop any further regression of the system, to try and defend whatever there is to be defended. But the point is, there is a lot that cannot be defended. And that is the problem here. And the problem is that this can probably not be changed by means of law. It's not the law that changes society. If we were to adopt rules, even you as states were able to adopt rules outlawing economic coercion completely, outlawing unilateral coercive measures completely, you would have made a revolutionary change, not just in the law, but in the very economic system that fundamentally underlies that law. Now, I'm all for you being able to make that revolution, but it is unlikely that this revolution starts with the law. It is far more likely that it starts somewhere else and is then reflected in the law. Now, I think I'm going to leave it there for now, and I'm looking forward to the discussion that I'm sure we will have later on. So thank you very much.
Thank you very much, Antonios, for raising the issue of retortions. I believe that the idea of discussing the terminology is incredibly important, and that's why I hope that in the future we will have the conference focusing on the terminological elements. As, for example, I need to say that in my reports, unilateral coercive measures do not include something what falls within the scope of retortions, but the point with which I can agree with Professor Tzanakopoulos that it's necessary to be very careful identifying whether there are international obligations or not, because today we are living in the world with many international obligations and many treaties concluded between states. And a very clear example can be the case which has been considered by the International Court of Justice and brought by Iran when the US at the very end withdrew in the loan process from the Treaty of Amity in order not to be obliged to restart fulfillment of the treaty. And therefore, the discussion of the issue of retortions, I'm really very happy that it was on the table and it will be discussed, is very important one, because we quite often forget about the existence of many treaties, like the treaties on the protection of investment, on cooperation, on amity, treaties on the Chicago Convention on Civil Aviation, and many other norms which shall be taken into account when assessing whether any legal norm has been broken. That's why I'm looking forward to the fruitful discussion. And therefore, I'm moving to our next panelist. I'm giving the floor to Professor Raul Rodriguez, Professor of North American History and International Relations, and currently the Director of the Center for Hemispheric and United States Studies at the University of Havana, who will present the topic US unilateral coercive measures on Cuba, terminology, enforcement, and overcompliance. So please, Professor, the floor is yours.
Thank you very much. First, I'd like to acknowledge the work of the Special Rapporteur and all the previous work, and the fact that bringing this conference together, which is, in my view, a critical platform to bring all the voices and move forward in this endeavor. I really appreciate the opportunity of being here and listening to my colleagues. As a matter of fact, I have already incorporated some of their comments in what I'm going to say. So it's already been very fruitful for me. When looking my talk, my presentation, I'll try to, with such a short time, to bring out my points. I will be looking briefly about terminology in the case of Cuba without going into the longer debate. We have time for that. Enforcement and overcompliance. When looking at most sender states today, or groups of states and target states, there is a clear north-south divide. The world major powers have increasingly resorted to geoeconomics and the application of unilateral coercive measures in pursuit of geopolitical objectives. There is indeed already incorporating a culture of punishment. In this context, among other aspects, it is paramount to discuss issues such as terminology, means and consequences of enforcement of unilateral coercive measures that often leads to overcompliance by private and state actors who seek to engage with illegitimately targeted states. Terminology, it's one important aspect that can contribute to this conversation, the one we're having here and we will continue to have, hopefully. As the use of appropriate terms and a set of concepts that is accepted and understood in the same way by members of the international community and this community gathered here, it's important to give us the opportunity to communicate, because there's a need to define the appropriate terms from north to south. When briefly analyzing the terms, we've already talked about that. Sanctions are mostly referred to as those adopted under Article 41, which was very good presented by the first speaker. Currently, we can see an increasing normalization of Eurocentric ideas that tend to manipulate the background beliefs which have prevailed for 500 years to fend off contrary evidence. Alfred de Sayas, another colleague which is here, he writes that we seem to be in an epistemological trap, caught in our own indoctrination and propaganda narcissism. It does seem that the rules-based international order is used loosely in place of international law, and is inconsistent in an inconsistent way to criticize the behavior of non-Western states and global South states, usually targeting wrongdoers, both individuals, organizations, which implies that the sender of the coercive measures has the legal capacity to pass judgment and punish a variety of actions of the target state. In the longer piece that I'm working on, we go into the differences of the terms blockade, embargo, sanctions, unilateral coercive measures, and so on and so forth. But I wanted to highlight in this presentation, for the sake of time, that the way to define the hostile and punitive actions by the United States government against Cuba for more than 6 decades has been, as a matter of fact, something that has been, as a matter of fact, used quite lightly. The reality is that this have different meanings and implications. In the case of U.S. unilateral coercive measures against Cuba, I would rather use the term semantic trap, which I think must be avoided without disregarding the epistemological trap. The official position of the United States government, the sender, has been to call the policy of unilateral coercive measures an embargo, as the original 1962 executive order by President Kennedy wrote. Using the term embargo, the United States intentionally, by extension, the Western corporate media, and even some well-intentioned persons promote the idea that the United States system of UCMs is just economic coercion, and it's a bilateral issue between Cuba and the United States, and consequently, in that sense, they may be legal. As to the legality of unilateral coercive measures using the term embargo, it is also safe to assert that not only obscures the fact that they are not approved by the Security Council under Resolution 41 or Article 41, but they also imply that the United States is responding to a hostile and deliberate act by the Cuban government, which in my opinion is not, but we don't have time to go into that. The U.S. system of unilateral coercive measures have evolved into a combination of statutes, regulations that have been modified over time, using every major method of of coercion or economic coercions by the sender state. And it is, and I'm again now quoting one of the other speakers, Ms. Bailet, is a big example of disproportionality. It's an all-encompassing policy which includes elements of extraterritoriality in order to compel other states and private actors into compulsory due diligence and increased overcompliance with US policy and legislations. It does function as a blockade, as an economic war, and is basically, and again, a punishment without a crime. The United States simply, if the United States simply adopted suspension of trade, it would be, we're talking about something else. The next would be the issue of secondary sanctions and extraterritoriality. When a state holds the monopoly of critical market and holds a singular role in the global economy, the UCMs imposed by that state affect as a function of, as if they were global. One of the significant cases, again, is the case of Cuba, and there are many examples that I'm not going to go into for the sake of time. But there is US legislation with a strong extraterritorial reach that really affects has a strong impact on everyday Cuban activities. There are also other measures, such as designating Cuba as a state sponsor of terrorism. It's an unilateral designation that makes Cuba a target for additional disruption, especially in the financial sector, and promotes increased scrutiny for private companies worldwide if they engage in commercial dealings with Cuba. Even for transactions that are clearly permitted under US law, companies and banks can expect inquiries from the Office of Global Security Risk with the US Government Securities Exchange Commission. For example, between August 2021 and February 2022, more than 100 foreign banks were included in enforcement actions by the Treasury Department. And then it will go to enforcement. The intensive use of geoeconomics, as I said earlier, as a strategic weapon by the United States and other Western states has increased in the last 2 decades, and they have tried to promote a coercion-based international order. In this context, the United States' actions to enforce their measures basically rest on the prominent hegemonic position of the Northern superpower have enjoyed since the end of the Second World War. The United States have maintained an overwhelming hegemony on the global economy, which has been grounded in a large measure with its dominant role in the financial system. Such external projection of the United States is more relevant in the Western Hemisphere, which is the hemisphere that has been intended to dominate by their own Monroe Doctrine. The United States is not only the world's more active user of unilateral economic measures. It is also the major enforcer imposing penalties on alleged US violators on unilateral coercive measures, and that face a variety of limitations, including access restrictions on fines and penalties. They put pressure on businesses worldwide and also interfere in the sovereign foreign policy choices of states and international organizations such as the European Union and other actors. It is indeed an aggressive enforcement that leads to one of the main consequences, which is overcompliance. Another colleague that was already quoted, and hopefully will be here later today, and Cecilia spoke about that, speaks about the sources of overcompliance as ambiguity of regulations and the severity of penalties. But for example, the US Treasury Department's Office of Foreign Assets Control requires that banks and other private actors not only abide by explicit language of the regulations of its own acts, but also exercise excessive, in my view, due diligence in regard with their customers and partners. In the case of Cuba, US officials act with strictness and tenacity, enforcing statutes and regulation which are frequently enacted and modified and add to the uncertainty and the aforementioned ambiguity and more overcompliance by private companies and banks. I will provide an example. There are more, but just for the sake of time. In 2016, OFAC, which is this Office of Foreign Assets Control in charge of enforcing all these sanctions, published a new not a new, but a different variation of these regulations, allowing for U-turn transactions, which Cuban national has interest. It allowed Cuban funds originating from non-US banks to be cleared through US bank systems and transferred back to non-US bank. This was approved in 2016. Then the next administration in 2018 revoked that authorization, only to be reinstated in May 2024 by this current administration. What I wanted to exemplify with this is basically that also it adds to overcompliance the way that this regulations had changed from 2 years to another year, and it adds to the uncertainty. And finally, last but not least, and it's already been discussed here, is that this imposition of unilateral coercive measures have no legal remedies. Companies have no ways of avoiding it because the instructions are in many ways vague, complicated, and not clear. And also they have no way to appeal what has the huge fines and disproportionate fines that are being imposed on them. Thank you very much.
Thank you very much for looking at this part of the problem. And now I'm giving the floor to Dr. Ksenia Kirkheim, the lecturer in the Department of War Studies, King's College London, who will pay attention to the effects of sanctions on third parties and sender states. Please, the floor is yours.
Hello, everyone. Thank you very much for inviting me. And I agree with everything that has been said so far. Thank you, Alena, for mentioning that analysis of sanctions should actually start with experts who reside in those countries, target states. Also, I agree with Antonio on the point that a revolution will not start anywhere else, will not start in the law, probably. We probably should expect some revolution coming out of businesses and business communities. So today I want to focus more, because a lot has been said so far on the impact on sanctions, on target states. I want to shift a little bit attention to the impact of sanctions on sender states and the impact of sanctions on broader communities, on third countries. So, and with a reference to the draft that has been presented to us, so businesses really pay attention now to the importance of human-based approach to business activities and the principle of due diligence and the humanitarian impacts of sanctions and transparency, because nothing is clear to businesses. And the worst thing is that they have very limited access to justice when it comes to asset freezes and seizures. And actually for businesses, there is no such distinction. They see as asset freezing as asset seizures. And the case of Iran and Iranian assets is the most demonstrative in this place. So the first thing is that most sender states now really focusing on how to improve sanctions efficiency, sanctions compliance. They're working very hard. But the problem with that and paradox that better sanctions compliance rarely translates in greater overall sanctions effectiveness. And it happens due to multiple unintended consequences that sender states have to look into. And they should, and actually analysis of sanctions effectiveness should always depart from a clearly defined political objective, kind of the end states that sender states are expecting to achieve. In my very recent paper, I was looking at the most prominent and most discussed points in academia in relation to what are the major goals of sanctions. So now I can quickly run through these goals, and you, while you listen to these objectives, think, have this objective achieved their target? So the first one is, the first objective behind sanction is to weaken the economic and military capability of sanctioned states by reducing their capacity to undertake aggressive military action. So, but did it work? What we witness now that sanctions actually serve as a catalyst for empowerment of some target states. The second objective is to limit the necessity of military action by sender states. It's kind of with a reference to what Woodrow Wilson would be saying, that sanctions serve as an alternative to war. He was saying that apply this remedy and there will be no need for force. But is this really happening? The risks of military conflicts has increased dramatically. Another objective behind sanctions is to signal to other states, kind of a factor of deterrence. But the opposite is happening. Sanctions serve as a wake-up call for other potential targets, and they actively try to develop mechanisms of self-protection. They diversify their partnership with other states. And one famous Chinese expert noticed that we never expected the US would ever freeze assets one day. And now, if the US stops playing by the rule, what can China do to guarantee the safety of its own assets? So there is kind of a growing perception now within the business community that they need to shield themselves away from sanctions. Another target is to promote national economic interests by some states, and there have been long debates now that sanctions in some cases serve as a form of neo-protectionism to shield domestic industry or promote geo-economic interests. And but what's happening? These sanctions undermine the very power base of sender states. And by power base, I mean that something that what makes economic sanctions really work. For the US is this dollar hegemony. For other states would be maybe control over some global supply chains. So this brings lots of friction among the business community. Another objective, to protect international law and to enforce the sanction state to comply with its core principles. But eventually impose sanctions in many cases, and we've seen today, challenge the international law. And honestly, when you speak to professionals in businesses, they say that we do not really care how much it is justified, whether sanctions are legal or illegal. What we care is the perception of what we see, what is legal, what is illegal. And we should pay lots of attention to what is happening with business communities and where money flow as the result of sanctions. And the last point is to promote sustainable development. This is another objective now behind sanctions, because sanctions are used tried to use quite skillfully to redirect supply chains, to restructure long-term business relationships, all kind of subjugate to the new expanded concept of national security. But the subjugation of business strategies and legislation for the needs of national defense and the surge of armed productions that goes alongside to foster sustainable development and address the problem of environmental degradation, it looks problematic because it does have the reverse effect. The reverse effect is that the military capitalism that we are kind of witnessing now diverts immense resources away from social, economic, and environmental needs. And the big battle is happening now over critical minerals. And then there is a chance that national defense agents and leading arms producers will drive this militarization of global capitalism to unprecedented levels that actually risk collapsing the entire system due to exhaustion of natural and human resources. So now coming back to the first point where we departed is what the effect of sanctions on the target states and on the third countries. I want to refer to Winston Churchill, who once observed, however beautiful the strategy, and in this case, I mean the strategy of sanctions compliance, you should occasionally look at the results. Because from the position of the sender state, they should really imply long-term strategic thinking of national security objectives. And strategic thinking for them would imply answering foundational questions about the long-term stability of their systems, not only in the military terms, but also as an investment destination, and the truthfulness of its legal system and the credibility of its commitment to partners. Thank you.
Thank you very much for bringing this perspective. I need to say that I'm looking forward to very fruitful discussion afterwards, because, for example, I fully disagree that we need to have a revolution in law. The law, upon my opinion, is already there. We have all legal norms, and if we just observe them, we will not have the majority of problems. But it's really good to look at this situation from different perspective, and I believe the perspective of businesses is very important, because one element which I was trying to reflect in the guiding principles as well as in the commentary, that quite often businesses stay not protected. And therefore, there shall also be a mechanism how to protect the businesses so that they do not overcomply. And it doesn't result in the challenges we're currently facing. With all that in mind, I'm currently giving the floor to Professor Pouria Askari, Professor of Public International Law at Alame Tabatabai University and Secretary General of Iranian Association for UN Studies, with presentation international law double standards in the case of unilateral coercive measures. So please, the floor is yours. Apologies for my misspelling of the university.
Thank you very much, Elena, and good morning, everyone. Well, in today's presentation, I'm going to talk about double standards of international law. But before that, I have to also mention that I do not see that there is a need to have a kind of normative revolution in international law. And I think when we are talking about countermeasures, it is not just tit for tat. There are two very important preconditions that we have to take into consideration. First is there should be a wrongful act proved. This means that an accusation is not enough. The states cannot just accuse each other that you are violating international law, so I have the right to violate international law, and I call it countermeasure. And the other thing is, even if there is a violation of international law proved, again, that sort of violation should be violation of erga omnes obligations. This means that in other cases, those who are not directly affected by the violation have no right to react in the form of countermeasure. And these are the things that we have to take into consideration when we are talking about articles on state responsibility. When it comes to retortion, the principle of non-intervention is actually a big obstacle. And apart from that, we have to take into consideration extraterritoriality is not accepted in international law. These are big obstacles that help us to not go in the direction of advocating for a kind of normative revolution. But apart from that, I do believe that in international law, we are facing double standards when it comes to the unilateral coercive measures. And today, with having all of this in mind, I really want to criticize the current legal system of international law. Let me start by saying that from an international law perspective, double standards refer to the inconsistent legal responses to similar cases or the uneven application of law to identical issues. This often occurs in the domain of human rights law, where states accused of violating international human rights norms may argue that such accusations are politically motivated, pointing to similar behaviors by other states that go unchallenged. However, in my view, another facet of international law double standards that is less frequently discussed is the lack of effective norms to address similar issues that are examined under different branches of international law for various reasons. I believe that the imposition of unilateral coercive measures serves as a prime example. Despite being discussed by numerous scholars and UN bodies for the significant suffering they can cause to the affected population, UCMs still lack clear regulations and restrictions within the broader framework of international legal system. In contrast, in similar scenarios of suffering, we observe rich rules of international law that clearly establish that certain behaviors are illegal or subject to significant restrictions. Let me provide you with some examples, and let me start with the prohibition of discrimination. While the discriminatory impacts of unilateral coercive measures, as we heard in today and also yesterday presentations, are evident in the devastating consequences of their implementation, the double standards in international law regarding the concept of discrimination hinder us from explicitly asserting that the absolute prohibition of discrimination is relevant in the arguments against the legality of these measures. A good and recent example is the case before the International Court of Justice brought by State of Qatar against United Arab Emirates on the application of Racial Discrimination Convention. In the core of its arguments, Qatar contended that because of the imposition of UCMs, the UAE has enacted and implemented a series of discriminatory measures directed at Qataris based expressly on their national origin. On February 2001, the court rendered its judgment on the jurisdictional objections raised by UAE and unfortunately declared that the ICJ does not have jurisdiction ratione materiae in this case. The court reached to this conclusion because in its view, the Racial Discrimination Convention, and I quote, was clearly not intended to cover every instance of differentiation between persons based on their nationality. End of quotation. Having said that, the court consequently argued that the term national origin in Article 1, Paragraph 1 of the Convention, in accordance with its ordinary meaning, read in its context, in light with the object and purpose of the Convention, does not encompass current nationality. With this very narrow interpretation, my dear friends, of the concept of national origin, which is, in the court's view, different from nationality, the ICJ deprived international scholars advocating against UCMs of a compelling basis to argue that these measures fundamentally contradict the obligation of state parties to the Racial Discrimination Convention. Let me move to another example, and this one is the humanitarian exceptions. As we all know, even the Security Council, as mentioned earlier today, is not permitted to cross the red lines of humanity and proportionality in imposing the sanctions. One of the latest developments in this regard is the adoption of Resolution 2664 in 2022. This resolution considers the importance of assessing potential humanitarian impacts prior to a Security Council decision to establish a sanction regime. A long-standing recommendation in line with the prerogative to design targeted sanctions measures. This means that even the most legally justified forms of coercion aimed at restoring or maintaining international peace and security must align with the limitations imposed by international law. In other words, international law norms and regulations also aim to mitigate the humanitarian impact of the United Nations sanctions. But is this true for the unilateral coercive measures as well? Well, unfortunately, there are no explicit obligation for the state imposing UCMs to address the negative consequences of these measures. The existence of illegal secondary sanctions aggravates this issue, as companies and other stakeholders may adopt a zero-risk policy leading to overcompliance with the UCMs. This serves as another clear example of double standards in international law regarding unilateral coercive measures compared to sanctions imposed by the United Nations Security Council. Now let me move to the law of war. We all know Article 2.4 of the UN Charter prohibits the use of force in international relations. It stipulates that aside from the use of force against the territorial integrity or political independence of states, any other forms of threat or use of force that are inconsistent with the purposes of the United Nations are also prohibited. The formula presented in this provision is difficult to understand without examining the meaning of the term force. In the years after the adoption of the UN Charter, countries in the Global South advocated for the United Nations to adopt a broader interpretation of Article 2.4 that encompasses economic coercion as a form of force. This perspective stems from the belief in the Global South that the devastating effects of coercive measures, particularly unilateral coercive measures, can be equivalent to military force. In some cases, these measures can cause even greater harm. However, the prevailing interpretation does not allow for a broader understanding of the notion of force to include more threats to peace and humanity. This narrow interpretation overlooks the fact of non-military forms of force lead to a humanitarian catastrophe that in many cases exceeds the devastation caused by wars. As we were listening to our dear colleague from Cuba or the colleagues from Venezuela, or I can talk about Iran. Moreover, many scholars argue that the rules and principles of international law governing hostilities, such as the principles of neutrality, distinction, necessity, and proportionality, use in bello proportionality here, I mean, in international humanitarian law, should also apply in the context of economic warfare. Though scholars advocating for this perspective also acknowledge that under the current framework of international law, implementing this idea is impractical. This is primarily because the rules and regulations of international humanitarian law apply only in situations of armed conflict. This highlights another stark example of the double standards that exist within international law regarding the humanitarian impacts of economic warfare. When a situation is classified as military conflict, numerous norms are in place to protect the victims. However, when the means of coercion, even if they have more devastating effects, do not qualify as traditional armaments, the victims are left without the protections afforded by international law. So in conclusion, what I want to say is, these examples demonstrate that the current system of international law, in both its normative and structural dimensions, lacks adequate tools to confront the challenges posed by illegal unilateral coercive measures, which have led to catastrophic consequences for individuals and communities, both directly and indirectly. In contrast, the same system has developed sufficient norms and structures to address the similar hardships and sufferings resulting from the use of force, armed conflicts, and human rights violations. These tools include various prohibitions against illegal conduct and provide humanitarian measures aimed at alleviating the suffering of those affected by such violations. These observations, my dear colleagues, highlight a troubling example of the double standards present in the current international legal system, a disparity that deserves attention in interstate, civil society, and academic discussions. From this perspective, any effort to promote and inspire discussions aimed at strengthening the norms and structures of international law to address the challenges posed by the imposition of UCMs are crucial. This is how we should assess the recent guiding principles developed by Professor Duhan concerning sanctions, business, and human rights. A code of multiple principles, which include general principles, principles for states, and principles for businesses. Digging into guiding principles, along with their comprehensive and significant commentary, illustrate how the work of the mandate holders of the Human Rights Council can advance discussions in the realm of international law to prohibit illegal forms of coercion and mitigate their adverse effects on the international legal order, which currently suffers from unreasonable double standards in this area. It is anticipated that concerned states and the academic community will actively promote this initiative. I thank you.
Thank you very much, Professor Ascari. I see that there is a huge interest to our discussion. I'm getting longer and longer lists of those who want to take the floor. And I believe as regard the elements which have already been mentioned, we might have a really good discussion afterwards, take into account that upon my observations as a mandate holder, I see that people affected by unilateral sanctions in reality appear much be less protected than those who are affected by sanctions of the UN Security Council, or those who appear to be a part of the military conflict, because at the moment, not a single UN document provides for the delivery of humanitarian assistance to those. But therefore, I'm looking forward very much for the intensive discussion afterwards. But I would appreciate our next speakers to keep within 10 minutes frame. Otherwise, we will not be able to give the floor to those who want to take it. And now I'm giving the floor to Dr. Ali Razbin, founder and president of the Paris Academy of Geopolitics and director of publications of the journal Geostrategic, with presenting the topic, the challenge of sanctions to international law. So please, the floor is yours.
Madame le professeur Alena Douane, Votre Excellence, Mesdames et Messieurs, bonjour. Unilateral sanctions seem to illustrate the establishment of a balance of power where the most powerful imposes its law on the weakest with impunity, taking advantage of the political, economic, and financial prerogatives and privileges at its disposal. These decisions, which are similar to acts of war, affect the legitimacy of public international law, the legal framework, and the responsibility of state and private actors, as well as human rights. In particular, the principles of state sovereignty and non-interference, freedom of trade and commercial, non-discrimination are called into question not on the country's sanction, but also on third-party state and actors, victims in a secondary manner of the extraterritorial effects of these acts. The concepts of protection and proportionality must be at heart of a sanction decision, which is only born and applied in a very specific context, and whose objective is to obtain the cessation of the conditions that preside over its implementation. Otherwise, it loses its status as an exercise of justice for and on behalf of the community, and enters the category of unilateral acts serving the interests of an individualized entity, thus disconnecting itself from the law from which it draws its reason for being and its framework. The most powerful states in the international system, geopolitically influential, have long been accustomed to keeping the rule of law vague for the protection of their own interest, and to limiting sanctions to the political and moral level, a capacity reinforced by the absence of binding force in the international order. Some of the strongest states capable to impose political and economic sanctions by themselves have exempted themselves from the rule of law, cancelling the taking of non-coercive measures. In application of the provisions of Article 41 of the United Nations Charter undermining equity and human rights on the sole basis of privileges, of political and economic power, and according to minority conception of the interpretation of law. This extraterritorial unilateralism consecrates the return of the sole balance of power in relation between member nations of the international community. The former US ambassador of Saudi Arabia, Mr. Charles Friedman, declared for Iran, on which the United States has imposed unilateral sanctions, where we penalize anyone wanting to trade with this country without any international legal basis for doing so. Thus, the principle that we once defended so vigorously, we systematically violated. End of quote. Indeed, Iran has been sanctioned by the West since 1979, and sanctions against it have become of real obsession for America, to the point of appearing as their only diplomatic instrument. The objective was to draw Tehran into the escalation of concessions under penalty of massive sanctions in order to reduce its civil nuclear ambitions to a minimum and to force it to give up its military prospectus. The external application of this geopolitization of the law of sanction by the United States has borne fruit vis-a-vis the third countries, its European allies. Indeed, Europe's losses in the face of American secondary sanctions against Iran are counted in multiple areas. Thus, the strongest imposes its law on the weakest by resorting to illegal maneuvers and by blackmailing all the actors, international society, by the series of countermeasures with extraterritorial effects in violation of the principle of public international law, real acts of war of an economic nature, such as the blockade against Tehran, a state of siege using the weapon of secondary sanctions. The sanction, therefore, aims to exclude the targeted state from in the international community. The fundamental right of the Iranian people, such as the right to health, to right to food, to education, and the right to development have been affected. These are in reality massive violation of fundamental rights. The reality of sanctions is not limited to freezing bank states or blocking fund transfers. The question of the survival of an entire population, particularly its weakest fringe, is raised in light of both the intensity and the duration of the application of the sanction affecting the country. For the United States, the idea of making a civilian population suffer as a collective punishment for the actions of its governments is compatible with the illegal principles that govern the decision to impose unilateral extraterritorial sanctions, which is the same as saying, punish the innocent to express indignation at the guilty. The suffering for civilian populations is meant to take them rebel against their government, or eventually overthrow, which is totally opposite to the objectivity and prudential virtues of justice inherent in decisions emanating from international law, the safeguarding of whose principles being the only bulwark against the progressive dissolution to the international legal order that we fear the witnessing today. Thank you very much.
Thank you very much for your presentation and this perspective. And now I'm giving the floor to Professor Gilles Emmanuel Jacques, the Vice President of the Geneva International Peace Research Institute and President of the Youth Center for Dialogue and Peace, with the topic unilateral coercive measures, the private sector and the sustainable development goals. Please, the floor is yours.
Thank you. Thank you very much for your invitation. Since the end of the Cold War, international organizations and regional organizations have adopted numerous multilateral or autonomous sanctions in order to respond to crises, like in the case of Iraq, Syria, and Libya, and as a way to avoid the use of force. But this last point is debated with regard to their effects on the human rights of the civilian populations of targeted countries. Countries like the United States of America frequently use similar means known as unilateral coercive measures and often called as unilateral sanctions. Their legality can be debated, and their negative effects on the human rights of the civilian populations are increasingly evidenced by the literature and reports from experts, NGOs, or various states and UN agencies. Moreover, these coercive measures adopted by international or regional organizations and states, as well as their negative effects on human rights, are also in contradiction with most of the sustainable development goals. While international or regional organizations and states adopt, implement, and enforce multilateral or autonomous sanctions and unilateral coercive measures, respectively, the private sector plays an important role in their effectiveness through compliance and what has been recently identified as overcompliance, both having also negative effects on the human rights of the targeted populations and contradicting at the same time the sustainable development goals. And it's useful to remind that 193 UN member states have pledged to implement these sustainable development goals. Legal cases against companies are usually related to criminal acts and serious violations of human rights, all prosecuted under national jurisdictions, which can include as well extraterritorial or universal jurisdiction in some cases. At the moment, there are no judgments or court decisions related to compliance or over-compliance with sanctions from companies and their negative effects on the human rights of targeted populations. However, cases are currently being opened in Switzerland and in the European Union by Russian citizens following the freeze or the seizure of their properties or bank accounts. At the international level, the main legal corpus related to the role of the private sector with regard to human rights is mainly constituted by soft law, typically like the OECD guidelines. And it doesn't mention or address at all the issues related to unilateral coercive measures, compliance, on over-compliance, as well as their effects on human rights. Let's talk a bit maybe as well about the legality and some legal considerations related to UCMs. UCMs are increasingly used since the end of the Cold War by various states, like the United States of America, in order to avoid a direct or overt use of force. This last point is debated with regard to the effects of multilateral or autonomous sanctions on the human rights of the civilian populations of targeted countries. In August 1999, UNICEF reported that UN sanctions had severely affected Iraqi children. Malnutrition, related diseases, and child mortality had increased significantly under the Oil for Food program, and available treatments were lacking. Well, some scholars argued that the report was biased and contested the death of 500,000 Iraqi children caused by these measures. But Madeleine Albright confirmed this death toll during an interview on 60 Minutes in May 1996, stating that it was, I'm quoting her, a hard choice, but the price, we think the price is worth it. The UCMs contravened various resolutions of the UN General Assembly, affirming the principles of sovereignty, non-interference, friendly relations, free trade, and various political or social economic rights, such as the UN General Assembly Resolution 2131, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, UN General Assembly Resolution 2625, UN General Assembly Resolution 3281, and the World Summit outcome of 2005. The former UN independent expert, Alfred de Zayas, considers that UCMs, by the human rights violations they cause, are a form of collective punishment, violating the Hague Conventions of 1899 and 1907, as well as the Geneva Conventions of 1949. In this perspective, he even added that they constitute prohibited use of force within the meaning of Article 2, Paragraph 4 of the UN Charter. And because of their demonstrable intent, they can be seen as well as crimes against humanity for purposes of Article 7 of the Rome Statute. Moreover, these coercive measures adopted by international or regional organizations and states, as well as their negative effects on the human rights of affected population, also in contradiction with most of the sustainable development goals. Let's talk now briefly as well about the role and the lack of responsibility or accountability of the private sector. UCMs are issued and implemented by a state, but they require the compliance from other states in order to be effective, and the private sector plays an important role in their effectiveness through compliance or over-compliance, and as well given the role of private sector companies in international trade, for example, in global supply chains or for international financial transactions. In the light of all available evidence provided by the literature and reports from UN agencies or NGOs, as well as the impact of multilateral sanctions on Iraqi children and of UCMs on the populations of Venezuela, Cuba, Belarus, Iran, Syria, and many other countries, it can be reasonably considered that compliance with UCMs leads to serious and massive violations of human rights. As companies play a role in this phenomenon, they could be held accountable for human rights violations caused by their compliance or their overcompliance. But there is a lack of a proper international legal framework to address this issue constituted by the legal responsibility of companies. Moreover, as companies are not always properly informed about exemption regimes, which can be perceived as complex and bureaucratic, or because of fear of secondary sanctions, they tend to over-comply with UCMs and thus to aggravate their effects on civilian populations. The UN Special Rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights, Aliona Duhan, gathered a significant amount of evidence showing clearly how UCMs and compliance or overcompliance from companies deprive civilian populations of proper treatments, especially for curable diseases, how they are deprived of their economic rights, their access to education, information, or even justice. At the moment, there is no international soft law or hard law instruments able to address effectively this issue. This issue is not addressed and not even mentioned by ILO conventions, the OECD guidelines for multinational enterprises on responsible business conduct, the World Bank guidelines, or the UN Global Compact. This issue is mainly addressed by some national jurisdictions, and there is a growing number of cases submitted to national jurisdictions, as shown by recent cases submitted to Swiss courts by ordinary Russian citizens, not people connected to the government, whose assets, properties, or bank accounts were frozen or even seized. And now let's as well talk briefly about the coherence, consistency, and relevance of the Sustainable Development Goals. The SDGs acknowledge various dimensions of human rights and are not legally binding, but they have a substantial influence on local legislations and have resulted in new laws and regulations at regional, national, and local levels. The elaboration, implementation, and assessment of the SDGs involved and still involve considerable resources, attention, and commitments from various actors, states, NGOs, companies, citizens, as well as important publicity and media attention, but their coherence and consistency can be seriously questioned with regard to the human rights violations caused by the enforcement of UCMs by states and by companies' compliance or over-compliance. As evidenced by the reports of the UN Special Rapporteur on unilateral coercive measures, Dr. Aliona Duhan, the negative effects of UCMs impact more strongly persons in vulnerable situations, including women, children, people with disabilities or with chronic or severe disease, the elderly, refugees, IDPs, migrants, people living in poverty, and others who depend on social or humanitarian assistance. It's the case for millions of civilians living in Cuba, Venezuela, Iran, Syria, Belarus, and many other countries put under unilateral sanctions regimes, whose food security, access to health and education, economic and human rights are violated. In the light of these examples, the direct and indirect effects, as well as the immediate and long-term effects caused by the enforcement of UCM by states and companies' compliance or over-compliance with UCMs, violate Sustainable Development Goals number 1, no poverty, number 2, zero hunger, number 3, good health and well-being, number 4, quality education, number 6, clean water and sanitation, number 8, decent work and economic growth, number 9, industry, innovation, and infrastructure, number 10, reduced inequalities, number 11, sustainable cities and communities, and number 16, peace, justice, and strong institutions, including human rights. So the Sustainable Development Goals may be considered as a crucial, noble, serious endeavor by the United Nations, its member states, the civil society, and the private sector. But in the light of all these examples showing how states enforcing UCMs and companies complying or over-complying with UCMs negatively affect the human rights of affected populations, their credibility, the credibility of the Sustainable Development Goals, can be seriously questioned. just like as well the credibility of the commitment and the good faith of concerned states and companies. This issue and gap should be addressed by more effective international soft law instruments and the adoption of an international hard law instrument dealing specifically with this issue. Thank you very much.
Thank you very much, Julie. Indeed, you raised a very important element concerning the fact that whether the existing facts allow us to see that it's not possible to talk about the unintended impact as soon as we already have lots of evidences. As I promised, we have 5 minutes break for those who want to have some coffee, but it will be really short. And there are printed recommendations for the non-governmental actors, so you're all welcome to sign. So we have a short break now.
Good.
So, Your Excellency, you see the academic part is really Dear colleagues, we finish our break and we continue.
Sí, sí. Yo me voy ahora a la 1, pero vuelvo en diciembre para
The next time I'm not giving a break.
reunión anual que tenemos todos nosotros.
So let's be back to the table and let's continue.
Sí, 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 sí. Tomas contacto con mi asistente que es. Sí, sí, sí. Ella
tiene mi teléfono,
Ajá.
WhatsApp y el correo.
Ok, perfecto. Muchas gracias.
Además, el tema que usted lleva para nosotros es muy importante.
Sí, ay, qué bien. Ay, estoy muy feliz de escuchar eso, sí.
Hemos leído todo su reporte.
¿De verdad? Ay, qué bien. Ay, bonito. Sí, pero hay que hacer puentes si ni vienen, si ni están allá, si ni escuchan. ¿Cómo se hace el puente? Tenemos que encontrar. Sí, 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 sí.
Professor, excellent speech.
Thank you so much. Just wanted to say.
Dear colleagues, I understand that everyone has already started the nice discussion during the coffee break, but I would appreciate everyone to be back and would appreciate if our keynote speakers are back. We will continue and take into account that I have a really long list of those who want to take the floor. And our break was much longer than 5 minutes because I couldn't persuade people to be back. I will appreciate your understanding so that I will keep our session 15 minutes longer than it was planned. And so our keynote speakers are back, and I have received requests from 2 states to take the floor as well. And now I'm happy to give the floor to the representative of Egypt.
Thank you, Professor Douan. Your work and dedication under the mandate is highly appreciated, putting together the guiding principles and also establishing the monitor for UCMs last year. I wish also to warmly thank the esteemed panelists for their elaborate, in-depth analysis of the current state of affairs of the international law and its linkages to UCMs. It was equally informative, eye-opening, and slightly grim, but yet I believe it's healthy for me as a civil servant from time to time to delve into the richness of academia. Yep. So as Professor Mohammed Azedin eloquently explained, and also Professor Antonius, it looks like the problem, and correct me if I'm wrong, the problem stands in the international legal order. It perpetuates the problem, the divide, the schism, and I will quote Professor Azedin, punishment without crime, crime without punishment. And here comes my question. And also I urge all the esteemed panelists to respond to the question on voluntarily basis without coercion. So what can we do as the international community right now to fix or review the system as addressed by Professor Cecilia? Is it possible, is it doable, or are we just drifting involuntarily and mindlessly towards an inevitable destiny? And we are just waiting for a cataclysmic event that will force start this review process. And here I would quote Professor Antonius, since the revolution will not start from the law. So from where would this revolution start? Thank you.
Thank you very much for the questions. And now I'm giving the floor to the representative of Cuba.
Thank you very much, Special Rapporteur. I want to thank you for organizing this panel. And also I want to thank the panelists for their interventions. My delegation believes that there is no need for a revolution of international law. That's the first thing. We understand that under the legal international framework is very clear that unilateral coercive measures are illegal. So that brings me to my second point, which is the legal nature. We invite the panelists on all academic professors that are here to go into the legal nature of unilateral coercive measures. We believe that they cannot be identified neither with countermeasures nor with retortion acts. They are a different institution that is used mainly for political purposes to obtain from the targeted state changes in their political system or decisions that those states are taking based on their sovereign right to do so. So there is a danger also on identifying or making parallelism between unilateral coercive system measures and the system of countermeasures or retortion acts. When we do that, we can send the message that unilateral coercive systems are also legal on international law, making that parallelism. Also, we invite the academic sector to go into the source of the right of imposing unilateral coercive measures. Is there a right to impose those measures against one country that has decided to build socialism, to build communism? Is on international legal framework, is socialism or capitalism illegal in the current international legal framework? So if we go into the source of imposing UCM, there is no source, there is no legal source. So they cannot identify, as I said, they cannot be unilateral coercive measures, they cannot be identified with countermeasures because there is no wrongful act in the beginning. So if we were dealing with countermeasures, the first thing that the state, which is going to impose those sanctions, the first thing that the state needs to do is to go through the diplomatic ways to address the problem. So it's a different situation that what we are dealing with here. Also, we do not favor to identify unilateral coercive measures with sanctions, because the legal framework of sanctions is very different from the unilateral coercive measures phenomenon. Based on that, based in the current international legal system, we do believe that there is a very clear tools for identifying that those measures are illegal. So I invite to you to go into the legal nature of this phenomenon and also the source of making imposing unilateral coercive measures against targeted countries. Thank you very much.
Thank you very much. Just before I continue with our list of speakers, I need to remind that we have the morning session and the evening session. That's why I definitely will not be able to give the floor to everyone who have registered for the this day right now, but we will have a chance in the afternoon as well. And I would appreciate if you are keeping within 3-5 minutes limit. So I'm currently giving the floor to Anna Chervy.
Thank you very much, and thank you, Professor Duhan, for giving me the floor and for the distinguished speakers. It has been incredibly helpful to actually expand what was set forth yesterday in the discussions, and your contribution, I think, helped to frame better what was presented as evidence of the consequences that these measures actually have on the countries in which they are imposed. So building on that, and also building on a recent research I concluded that looked at the impact of the restrictive measures also on the ecosystem of ascending country like Italy. And when I say ecosystem, I talk about private sector, including also non-governmental organization, the public sector, custom regulators, and so on and so forth. I was wondering whether, while reflecting also on the proportionality concept, whether the safeguards that have been introduced in UCMs so far, often going under the name humanitarian exemptions or humanitarian carve-outs, having the name already a misleading concept, because they mostly confine the carve-outs and are interpreted in practice into the legislation as covering the action of specific actors that move into that humanitarian realm. And that those are most prominently NGOs or international organizations, including the UN. And this leaves out the system that should sustain the humanitarian action, but most importantly, the accessing of basic rights of the populations that live in those countries. So I was wondering whether we should move away from the concept of humanitarian exemptions or carve-outs and actually talk more about perhaps proportionality carve-outs. Proportionality carve-outs that include, of course, the humanitarian actions, but also include more explicitly the protection of human rights and also legitimate business that should continue regardless of the different measures that each country has decided to take on one another. And I'm saying that because particularly when it comes to the private sector, and this was also mentioned by other speakers today, we are in a situation, for example, whereby the financial system, and this is the case, for example, in Europe, has been delegated by the states a duty to control the transactions that are happening within their realm and to report any potential violation or any potential breach of regulation, them being anti-money laundering regulation or counterterrorism financing regulations. So as the states are also delegating out part of their control responsibilities, it becomes very difficult to keep confined the safeguard just to, as I said, a humanitarian action. So I was wondering if any of you had some thoughts on this. Thank you very much.
Thank you very much. And now I'm giving the floor to Mona Chourbadji from UNDP Syria.
Thank you. Ladies and gentlemen, distinguished colleagues, esteemed academics and speakers, I'm honored to contribute to this critical discussions at such a significant platform. Today's topics underscores the necessity of bridging academic research and actual business practices. The expertise of academic here is crucial for grounding for actions and evidence and theory. My intervention aims to address drivers of investment businesses and potential exclusion in the context of UCMs, drawing on insight from discussions made with the business and private sector to explore practical and sustainable solutions. Although countries primarily acknowledge and adhere to international law and UN Security Council sanction list, international and local financial institutions within their jurisdictions are also required to consider UCM's list. This is to avoid exposure to secondary sanctions or penalties of isolation or financial burdens, even if these sanctions are not explicitly recognized under the jurisdiction's law. Such practices often lead to compliance, in fact, with the UCMs by the economic activities within these jurisdictions. However, the dynamics of international investment and businesses, particularly in financial sector, highlight significant challenge posed by UCMs. International financial intermediary often adopt strict adherence to UCMs, incorporating them into their anti-money laundering and compliance screening protocols to avoid isolation from the legal linkage to the all international official channels of business and international financial channels. Nevertheless, United Nations Security Council resolution have reaffirmed the United Nations call to all states to sign, ratify, and implement the relevant international conventions criminalizing terrorism and terrorist financing. United Nations General Assembly Resolution 6288 issued in 2006 also encouraged member states to implement the comprehensive international standard on combating money laundering and the financing of terrorism, recommended by the Financial Action Task Force. However, in practice, combining between UCMs and the anti-money laundering and counter-financing terrorism compliance practices create, as it's called in business language, a common practice, which indeed complicates the humanitarian operations and exacerbate the negative impact of on the sanctioned countries. A critical distinction must be drawn between anti-money laundering and counter-terrorism financing from one side and the enforcement of UCMs. Currently, UCMs are often conflated with the UN Security Council sanctions, leading financial institutions to treat them as equivalent in compliance practices. And the emerging trends of scrutinizing supply chains and trade routes, in addition to financial transactions, further complicates the importing and exporting landscape for countries under UCMs. This has raised critical questions. How can we effectively approach and engage in dialogue with the Financial Action Task Force and international and regional financial institutions and private sectors as well? The objective may not be limited only to addressing the responsibility for the unintended consequences of UCMs, but also could focus on discussing the guidance presented. And additionally, it's essential to examine the regional impact of UCMs and explore practical risk-based solutions within the broader network of interconnected banks and the trade routes, and consider for sure the supply chains, which directly affects the states and countries subject to such measures. Thank you.
Thank you very much. And now I'm giving the floor to Elizabeth Valdez Miranda Fernandez from the University of Havana Law Faculty.
Thank you very much. I will get a second of my short time to extend my gratitude to the organizers and participants of this timely and necessary international conference. We hope it will continue in the future. I also want to share brief reflections on challenging international law issues, and I have also a question for one of the panelists. So if you agree, I will start with the reflections and then finish with the question. Going back to the terms, we must insist on the urgent need to establish a precise definition of international sanctions, as there is currently no clear concept under international law or a specific multilateral treaty governing them. Instead, we witness the proliferation of unilateral coercive measures mislabeled as sanctions, which lack proper legal frameworks. These so-called sanctions often evade international oversight, demonstrate alarming disproportionality, and frequently constitute serious violations of international law. We consider international law already provides categories to classify actions undertaken without or beyond UN Security Council authorization, such as reprisals, countermeasures, and unlawful self-help measures. Supporting the practice of labeling unilateral actions as sanctions undermines the horizontal nature of international system, creating a hierarchy between sanctioners and sanctioned that unjustifiably legitimizes violations of international law. It is therefore critical to avoid the indiscriminate use of the term sanctions. As Professor Ascari was highlighting before, unfortunately, international law currently does not classify unilateral economic coercive measures as violations of the prohibition of the use of force, even though they often substitute armed force and have similar effects to military conflicts. As a result, the principle of non-intervention often becomes the last line of defense against such measures. However, a concerning trend in doctrine and practice is the erosion of the principle by setting excessively high standards for what qualifies as intervention. Even if unilateral economic measures are not categorically prohibited by customary international law, this does not mean they are compatible with the principle of non-intervention. Their compliance must be evaluated based on the coercion involved, the damage caused, their duration, and their purpose. And this issue is particularly critical when such measures are justified on human rights grounds, as human rights, while not exclusively within states' domestic jurisdiction, are often misused as a pretext for intervention. Coercive measures frequently harm civilian populations, depriving them from the essential resources and instrumentalizing their suffering for political aims. Therefore, international human rights obligations must clearly limit such practices. Finally, I would like to briefly address the case of Cuba and the annual UN General Assembly vote on the US blockade. The widespread rejection of the blockade highlights its inconsistency with international law and may indicate an emerging opinion of jurists against unilateral coercive measures. While these resolutions are not binding, their consistent and near unanimous support could suggest the development of a customary norm prohibiting such practices, which is something that deserves further attention and follow-up from the perspective of international law. This is basically what I wanted to share, but now I have the question for Professor Antonio Tsanakopoulos, if it's possible. And it's referring to coercion, of course, that I think it's one of the most complex and controversial topics we are dealing with when we talk about UCMs. I have to confess that I have read your work, so I have a general idea of your position here, but I've always wanted to ask, and I take the opportunity today, where do you draw the line between a legal retortion motivated, for example, for one of the examples you were using today? I don't like your political system, which is possible. And for example, when a state's principal trading partner decides to cease trading unless that other states just abandon their political system. Because in any case, it's part of the example, but I think it's not the same. So I think it would be interesting, at least for me, to know where you draw this, for me, very precise line between these two important figures, which remit to different legal frameworks in international law. Thank you very much.
Thank you very much. And now I'm giving the floor to Mr. Dragan Dakit from the University of Kra. I'm apologizing. So as I understand, I'm not able to read it. So University of Kragujevac, Faculty of Law. So apologies.
Thank you, Your Excellency, and other excellencies and distinguished participants of the meeting of this highly important conference, as I agree with my previous speaker colleague. On this occasion, I would just like to use the chance to draw your attention to, I would say, specific situation which is currently going on in Bosnia and Herzegovina in respect to unilateral sanctions imposed by the United States of America against individuals, entities, and persons in this country. The situation is briefly just following. Before I discuss it, I just would like you to bear in mind that central government institutions are passive. They are not providing any remedial mechanism or actions for the persons affected by those sanctions in order to protect their human rights or to try to compensate it somehow. So the Bosnia and Herzegovina is a very complex state. It consists of two federal or confederal units. Its internal structure was established by the Dayton Peace Agreement 29 years ago. And reasons for intervening in this way by unilateral coercive measures is actually exercise of constitutional powers of one of the entities. So the highest officials of that entity, called Republic of Srpska, were imposed by the sanctions because they exercised their constitutional powers. So the sanctions went deeper, and some of their family members also were designated by the sanctions, and some companies as well, which resulted in the great human rights violation of the sanctioned persons and persons related to them. Also, many employees of those companies are deprived of their basic human rights since they are unable to use banking services for internal payment process. So they are deprived of receiving salaries and this basic human rights, actually. Also, companies are unable to have their accounts unblocked or to open a new accounts, etc. So this is just one of the aspects of the problem. What I would like to hear from other speakers, and just to develop the thought about it, how sanctions on these occasions are actually used as a mean to restrict, I would say, self-determination, because the internal structure of Bosnia and Herzegovina results from right to self-determination, which was codified by an international treaty. Now, unilateral coercive measures are actually used as a mean to, let's say, reconstruct internal structure of the Bosnia and Herzegovina. Just another maybe perspective which could contribute in further debate. Thank you very much.
Thank you very much. And now I'm giving the floor to Mr. Robert Walker from the Beijing University, Beijing Normal University. Please, the floor is yours. He's joining online.
Thank you very much for giving me the opportunity to speak. As we await the arrival of the second Trump administration, I'd like to draw attention to situations in which trade tariffs become unilateral coercive measures and therefore illegal. In the US Trade Representative's report to Congress 2023 that was published at the beginning of this year, there's a really intriguing statement which says, the mere fact that decisions in the marketplace are often made based on the objectives of the state rather than based on commercial considerations distorts China's economy and in turn the global economy in ways that can damage and weaken the economies of China's trading partners. To the extent, therefore, that the state represents the people, the crime which is to be punished is to put the interests of the people ahead of the interests of capital. The document goes on. It, namely the problem, is also exacerbated, of course, because China is the second largest economy in the world and the largest trader amongst WT members. In other words, it's an effective competitor. In the US Trade Representative's report for the previous year, we understand the strategy. It makes it clear, I quote, "It has become clear that new and more effective strategies, including strategies that involve taking actions outside the WTO where necessary, are critically needed to address the unique and very serious challenges that China's state-led, non-market approach to the economy poses. So previous United States administrations have been perfectly clear that the actions that they are taking are outside the legal framework provided by the World Trade Organization. And I commend everybody the Visit to China report produced by Alina in her role as Special Rapporteur, which states very clearly that the unilateral sanctions against China neither conform with international law, nor meet the criteria of collective countermeasures. And she documents many reasons why and some of the consequences. As we anticipate in the opening months of next year, an intensification of this global economic warfare, it strikes me that the victims are going to be numerous and the collateral damage quite extreme. Our only defense becomes the guiding principles which Alina is presenting and which we are discussing today. We clearly need them very much indeed. Thank you.
Thank you very much for the support. And I apologize to Professor Desayets. I will not give him the floor right now because he will speak in the second part of our meeting. Otherwise, other people will not have the possibility to take the floor. And I'm currently giving the floor to Esther Salamanca from New Humanity. Please, the floor is yours.
Mr. Special Rapporteur, thank you for giving me the floor. Excellencies, dear colleagues, I'm Associate Professor of Public International Law at the University of Valladolid in Spain. I speak in the name of New Humanity, an international NGO with generalist consultative status. In our comments to the call for inputs, we confirm our support for the mandate of the Special Rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights. International law has evolved in the last decades from an interstate approach to a person-centered approach. However, many topics remain in the middle of that process. That is the case of the impact of multilateral or unilateral sanctions on the target state's population. Sanctions regimes have divided the international community for decades and has worsened in the recent years, as we can see in the lack of consensus among members of the Human Rights Council and the General Assembly. Despite the efforts to make the management of sanctions more clear, consistent, and transparent, and to improve humanitarian exceptions, the reality is that the humanitarian actors on the ground report the operational complicities in the delivery of humanitarian assistance, as the rapporteur relates in her report on the visit to Syria. We welcome the publication of a commentary of the guiding principles. It's an extensive, systematic, and coherent document. In our view, this document needs a study in deep from the point of view of international law. So we appreciate the whole of this international conference, and we have taken note of the deliberations, especially the clarification of legal concepts and terms, which is very much needed. We will make some preliminary comments on the draft guiding principles. First, we suggest completing the reference to Article 1 of the Universal Declaration of Human Rights with the duty of fraternity, and therefore to include the principle of solidarity in the list of general principles after the principle of humanity, as it has been defined in Article 1 of the revised draft declaration on the right to international solidarity. Indeed, Article 9, paragraph 1F of the revised draft declaration refers to avoid the deployment of unilateral coercive measures that are inappropriately or too broadly targeted, or which contribute to the exacerbation of human rights violation in affected states. I would like to know the opinion of the independent expert on international solidarity at this respect, who is here. Second, we fully support the implementation of the humanitarian precautionary principle in this context and the launch of the monitoring and impact assessment tool. This is a very important development of the mandate, and we want to congratulate the Special Rapporteur for that. I have a question on this regard. How do you expect this tool to be used? Third, we observe that the principle of due diligence appears in the guidelines as a principle of business, But this principle has a broader content that is mentioned along the commentary. So I wonder why it's not included as a principle for states and international organizations too. And finally, in the hope that these guidelines will achieve their objective, I also wonder if it would be appropriate to add a clause underlying that the implementation of the guiding principles do not remove responsibility of states or the person or group of persons against whom legal coercive measures are adopted, as they are strictly humanitarian in nature. Thank you very much.
Thank you very much. And now I'm giving the floor to Professor Michael Strauss from the Center of Diplomatic and Strategic Studies in Paris. Please, Michael, the floor is yours.
Thank you, Professor Duan, and thank you to others involved in organizing this conference for the opportunity to speak. I'm sorry I can't be there in person. Actually, I'm not too sorry. I'm in a very nice place in southern France for a previous academic commitment, but I do wish that it would be nice to interact with you in Geneva. In any case, I'll talk briefly about secondary sanctions, the sanctions imposed against presumed violators of unilateral sanctions. Secondary sanctions are meant to achieve worldwide compliance with unilateral sanctions and can target presumed violators no matter what country they're in. Secondary sanctions are criticized in international law mainly on two grounds. One is their extraterritorial reach in penalizing parties in third countries. The other criticism relates to human rights. Secondary sanctions broaden the harm to human rights that the original sanctions initiate in the target state. They also violate the right to due process of the penalized parties in other countries. That right, of course, is elaborated in the International Covenant on Civil and Political Rights. It's well documented that sanctions harm the human rights of a target country's population in a lot of different ways, and also that humanitarian exemptions don't really work too well in preventing this harm. And yet there's one human rights argument against the legality of secondary sanctions that hasn't really been discussed until now, to my knowledge, and that is Article 23 of the Universal Declaration of Human Rights says that everyone has the right to work, everyone has the right to free choice of employment, and everyone has the right to protection against unemployment. Secondary sanctions deny or diminish these rights. By penalizing companies in third countries for doing business with a state targeted by unilateral sanctions, secondary sanctions can be seen as a way to suppress competition. They block foreign companies from competing in the target state's market during the same time period that companies in the sanctioning state can't do business there. This prevents companies in third countries from taking over the market share of these companies. If third country businesses were allowed to build or expand their own commercial relationships in the target country, these might become durable, which would be to the detriment of companies in the sanctioning state once the sanctions are lifted. Put another way, secondary sanctions try to keep everyone out of the market in the target state until businesses in the sanctioning state can resume activity there. This works to the advantage of companies that have already developed business ties in the target state, which of course means companies in the sanctioning country because they work to the detriment of companies. I'm sorry, I'm losing my place here. If companies in third states are allowed to expand their commercial relationships in the target states, these might become durable, which would be to the detriment of companies in the sanctioning state. That's what I want to try to say. By keeping these other companies out of the market in third countries, it works to the advantage of companies that already have developed business ties in the target state, which of course means companies in the sanctioning country. Secondary sanctions can therefore be seen as a new form of protectionism that reserves the market in the target country for businesses in the state that applied the original sanctions. In thwarting foreign competitors from filling the gap in the target country's market, secondary sanctions inhibit job creation in third countries around the world and thus limit the right to work in those countries. They restrict possibilities for employment and thus reduce opportunities to exercise the right to free choice of employment. And they erode the protection against unemployment that job creation accomplishes. Secondary sanctions, of course, also inhibit the right to development in third countries everywhere by preventing their businesses from taking advantage of opportunities in countries that are sanctioned by others. Until now, secondary sanctions have been associated with the United States, but the European Union has now recently approved the concept. So one can expect their use to increase and potentially spread. The time to challenge their legality is therefore now, before this happens, and before the harm to human rights becomes wider. Thank you very much.
Thank you very much, Michael. And at the moment, I need to close the list of those who want to take the floor from the ground and to ask our keynote speakers to provide a feedback. We'll appreciate if each of you will stay within 2 minutes limit. So Jill, please start. Let's start from the side. So no comments?
Yes, thank you very much. Just a quick comment on the very interesting comment which was raised by our colleague from University of Havana. I just want to remind you that the comment was, okay, we have too many resolutions adopted by the United Nations General Assembly and also the Human Rights Council. So can we talk about a kind of rule of customary nature as a result? I would say this is a topic that we really have to go into the details. But at least in 2018, when Professor Michael Wood finished his work as the Special Rapporteur of the International Law Commission working on the subject of identification of customary international law, what he is proposing is really helping because of two reasons. The first reason is the International Law Commission is now telling us, if you are looking for a practice that the International Law Commission is calling it the general practice as the first element to identify there is a rule of customary international law, this practice has to be widespread, representative, and consistent. So from this point of view, we can say that when we have a very good number of resolutions which are repeating themselves, saying that UCMs have some restrictions, generally speaking, they should not violate human rights or the other principles of international law, including, as mentioned by our colleague from Spain, principle of solidarity. I fully agree with this proposal. Well, yes, it is representative, it is consistent, and it is widespread. From the other side, the International Law Commission is telling us, in accordance with the customary international law, to identify a rule of customary international law, we still need the two factors, i.e. the state practice, or let's say the general practice, and the opinio juris, as you have already mentioned. But what is interesting is the work that the Commission was supposed to do was how to identify the general practice and the opinio juris. And Professor Wood is telling us, if you want to identify there is a general practice, one of the ways to dig into and to discover is to check the resolutions adopted by the international organizations. So here you have it. There are resolutions adopted by the Human Rights Council and the General Assembly. On the other side, when Professor Wood is going to answer the question, how should we identify there is opinio juris, again, the International Law Commission is referring to us, among others, the resolutions adopted by the General Assembly. So here you are. You have plenty of resolutions. There are consistent, representative, adopted. The last one was adopted by 190, if I'm not wrong, huh? And of course, they are widespread. And from the other side, they can represent the general practice and the opinio juris at the same time, in accordance with the finding of the International Law Commission. So I would say, with the findings of the International Law Commission, we have really moved in a very good direction to answer a positive answer to your question. Thank you.
Thank you very much, Professor Rodriguez.
And sorry. Is it? It's fine? No, I was just going to say that I'm looking forward to the answer from Professor Saracalpus to my colleague from Havana. And we can also talk more about that over lunch ourselves. So no more time here. Go ahead.
Thank you very much.
I thank those who made interventions. They are very invaluable. And with your kind permission, I'm going to adjust my paper accordingly. So thank you very much for that. Actually, the distinguished representative of Egypt started the interventions, some sort of where we are heading to. I think that we need immediate comprehensive action. This is the first thing. And there are many things achieved which we can build upon, and it should not take much time, really. It's high time to do something. Second thing is that not to confine, to compartmentalize our work only in the legal aspect. We have to go to the root causes. Because if you have a sanctions situation, mostly it comes from a sort of disagreement over a regime or violence somewhere, with an internal conflict, international conflict, whatsoever. This is the product of two things. I'm speaking only of two things because there are other things which God only knows. I cannot pretend to know. Number one is lack of preventive diplomacy, not failure, lack of preventive diplomacy. In many situations happening today, had preventive diplomacy worked correctly and efficiently, this whole situation might have been avoided. Second thing, intelligence. The word intelligence refers to an intelligent mind, but sometimes intelligence is stupid. And there are so many intelligence failures. And this aspect has to be addressed in a very straightforward manner. So we have to deal with the root causes which triggered the situation, which eventually led to the imposition of sanctions, be it Security Council or other. Third, there was some reference to the general comment of the Committee on Economic, Social, and Cultural Rights on sanctions, because these rights are most vulnerable to sanctions, of course. General comment has been adopted 27 years ago. As such, it's not sufficient. However, it is useful. And I think that this committee, the Committee on Economic, Social, and Cultural Rights, have to be encouraged to two things. Number one, supplement, update, and adopt, even as is. Because so far it has not been sufficiently adopted. I also urge state parties who are under sanctions to invoke Article 17.2 of the International Covenant on Economic and Social and Cultural Rights, as sanctions are factors which are impeding the implementation of the covenant insofar as economic, social, and cultural rights are concerned, because they too hit the notion of maximum available resources. Point number 4, the legal aspect, very quickly. Are these coercive measures legal or not? To my mind, in accordance with Article maybe 15, if I remember, 52 or 53 of the Charter, if I remember correctly, maybe not. But this article used the word enforcement measures. And the word enforcement measures applies to Articles 41 and 42. Is enforcement measures is the same as the use of force in the sense that it was the philosophy of the Charter of the United Nations that the use of force is banned. And it's only Security Council, because when you look at Article 51, that's the only exception. In case of armed attack, you defend. So I think these are factors to be taken into consideration, but action, it's high time. It has to be carried out immediately, not waiting for a legal revolution. It should be a mental revolution. Thank you.
Thank you very much. I would appreciate keeping within 2 minutes. Please, Cecilia.
Yes. Proportionality in a broader sense, exactly because the humanitarian exception has proved much too narrow and the impact has been absolutely devastating. So we need to move in that direction of broadening the scope of analysis to really remedy the limitations for the actors on the ground. So thank you very much for that illuminating perspective. Solidarity obviously is a universal principle and it should be guiding any type of new instrument that we are creating, whether it's soft law or approaches. But the current comment on preventive diplomacy is something that could maybe be used in the context of how do we implement solidarity in practice. We have to create institutions that would look at preventive diplomacy, but also reactive diplomacy when you have an instigating state and you have a targeted state that the diplomacy has broken down so badly. Then we have to identify which are the parties that can come in and provide that preventive and reactive diplomacy to create a new solidarity dialogue to end the impact of disproportional UCMs. So that could be within the UN, it could be regional actors, it could be interfaith groups, but maybe we have to look creatively at thinking strategically in identifying them and empowering them to act in a preventive and reactive way. Thank you.
Thank you very much. Dr. Rasbin, please, the floor is yours.
Thank you very much. I am agree with Professor Mimi about the Article 41.
Thank you very much. Senior, please.
Thank you very much for your comments. So the first thing I want to say is that sanctions is not an alternative to war, but it's an economic weapon. The second thing, I agree with Michael Strauss on the point that sanction is a form of neo-protectionism, that sanctions enforcing agencies promote geo-economic interests of the sender states. And now we witness stark competition in the tech sector and in the energy sector. Since the shale gas revolution, the United States, for example, turned from the major consumer into major producer. We have lots of LNG projects around the globe. And now the competition shift from the competition over control over energy resources into competition over export markets such as the European Union. And what's important for us to understand that all this difficult, complex supply chains have evolved throughout centuries and decades upon the principle of efficiency and reduction of costs. That's important and driver for business. But reorientation of supply chains according to the logic of national security agenda, securitization of everything, drags us into the risk that it will break down efficiencies and spur inflation across the channels, and also disrupt trust among the businesses, induce militarization in many sectors, because that's what follows after the disruption of trust. and excessive militarism will drive resources away from sustainable development.
Thank you very much, Antonio. 2 minutes.
Can't do it in 2 minutes. She'll kill me. All right.
Technical stuff cuts us off.
Okay. I don't, have to invite me to Havana, and I'll be very glad to come and talk to you about this for 3 days. But in very, very quick terms, we're also bleeding people. We lost the delegate from Egypt who asked a very nice question. But in very simple terms, a unilateral measure, anything that a state does by itself is a unilateral measure. Fair enough so far? Okay. That unilateral measure may be lawful or unlawful. It is lawful if it does not violate any international obligation incumbent upon that state. I am state A. I do not have an obligation to trade with state B. I stop trading with state B. That's lawful. State B doesn't like that. They think they do that because I don't like communism. They may be right. In fact, they are right. But there is nothing that they can tell me, because I am not required by the law to trade with them. And so that's absolutely fine. So the first step of analysis is the measure you're taking lawful? Is there any international obligation against it? There are many international obligations that may be against the measure you're taking. It may be an exorbitant assertion of jurisdiction if you're trying to regulate conduct extraterritorial and all that stuff. So I'm happy to discuss all of those. But that's the first analysis. The second analysis is, if the measure is prima facie, so at first sight, unlawful, is there any justification for that measure under international law? Countermeasures is a circumstance precluding wrongfulness. So there you would have to say, I'm taking this measure because I'm responding to a previous violation. Now, we've heard things like, oh, you have to prove this. To whom? You do not have to prove this to anyone. I'm sorry, this is how international law works. International law is a decentralized system. That means I assert that you are violating the law. I do this at my own risk. If we go to dispute settlement later, or if we somehow resolve the dispute through diplomatic means, it may be found that I was wrong and you were right. And that has happened many times, right? But as long as there is no resolution, my word is as good as yours. And so if I assert that you violated the law, you have the right to then assert that you did not violate the law, that my proposed countermeasure is in fact the first violation, and then you can hit me with countermeasures. The response to that is, well, if I'm the United States and I'm taking countermeasures against you and you're Togo, well, good luck with that, taking countermeasures against me. Fair enough, or actually unfair enough. But you know what the problem is? Life is unfair. All of law is unfair. How many rich people do you know who are in prison? No, I'm not saying go home. I am saying you need to understand what the law is there to do for you to be able to use it properly. It can be used for certain things, and there are certain other things for
which we do not have time. We will continue
for
this
which it
discussion,
cannot.
Please.
I was going to the Egypt thing about the revolution, but
We will discuss it a bit later. So I would like to thank all our keynote speakers, and I'm absolutely sure that we need further discussion in the afternoon and the new conferences as well. Just want to very briefly, as 2 questions were asked to me directly. The guiding principle addresses the due diligence both for businesses and for states. And one of the responses is that businesses are obliged to ensure that these states are obliged to ensure that businesses under their jurisdiction control do not violate human rights. And as a result, states are obliged to provide certain protection to the businesses, because the principle of due diligence is very comprehensive. It talks about the obligation to take legislative, judicial, institutional, operational, and many other elements. Very last message which I want to share for non-governmental actors: the recommendations are currently online on the webpage of the conference. Those who are not here and want to sign at the same time, please send the message to the email of the mandate. With all that, I'm wrapping this session and would appreciate that we thank our keynote speakers. So thank you very much. Ladies and gentlemen, so thank you for coming back after lunch. It's usually very uneasy, but I'm glad to see you all back. And we are starting our second academic session of the discussion. We have the amazing list of keynote speakers. I would take into account that all of us have observed how intensive the discussion was, and I have a long list of those who have registered to take the floor. Afterwards, I would really appreciate you if you keynote speakers keep within 10, maximum 12 minutes, not being too long, because otherwise we will not be able to give the floor. And secondly, there will be coffee outside, but I will not make the break because otherwise no one will allow us to stay here longer than 6 p.m. So therefore, if anyone will want to have coffee, you can just leave outside, pick up coffee, enjoy that, and be back. So with all that in mind, we are starting our afternoon sessions. It will be a bit less focusing on general notions and more specific, relevant to international adjudication, to the functioning of businesses, to the work of lawyers. And at the first of our keynote speakers, I'm giving the floor to Professor Alfred de Zayed, Professor of International Law at the Geneva School of Diplomacy, who is a former UN independent expert on international order. And he will talk about the UN guiding principles on business and human rights in the context of unilateral coercive measures proliferation. So Alfred, please, the floor is yours. It's fine.
Thank you very much, Alena. Excellencies, friends, John Ruggies' Guiding Principles on Business and Human Rights launched the normative process of defining what I would call the civilizatorial and legal responsibility of business enterprises for the human rights impacts of their actions and omissions. The general guiding principles do not address many issues that require closer attention, including the responsibility of business enterprises for the adverse human rights impacts resulting from their implementation and hyper-implementation of illegal unilateral coercive measures, notwithstanding the numerous General Assembly and Human Rights Council resolutions condemning UCMs as contrary to the UN Charter and international law. There has been a surge in the imposition of UCMs by states and little or no resistance from business enterprises that have become complicit in the ensuing violations of human rights, including the right to life, the right to food, the right to clean water and sanitation, the right to housing, etc. In an effort to minimize the risk of heavy penalties for failure to fully implement UCMs, business enterprises have become instruments in the enforcement of UCM regimes. At the same time, states are failing in their obligation to give protection, diplomatic and other protection to business enterprises registered or operating within their jurisdiction when businesses suffer penalties because of refusal to implement UCMs. In principle, states have an obligation to exercise diplomatic protection on behalf of their citizens who become victims of extraterritorial acts by foreign entities and should invoke the jurisdiction of the International Court of Justice in contentious cases, request an advisory opinion to clarify the violations of international law involved and define the level of compensation due to victims. Other avenues of redress could be the permanent court of arbitration or other settlement mechanisms, including investor-state dispute settlement. Resolutions of the General Assembly and Human Rights Council condemning UCMs should be the subject of continuous debate in national parliaments and governmental agencies, including national human rights institutions. Specific rules should be adopted to define the civil and penal liability of corporations for their complicity in the enforcement of UCMs. Victims must also have access to effective remedies. The incompatibility of UCMs with the spirit that led to the adoption of the guiding principles is a theme that could and should have been addressed by the Working Group on Business and Human Rights, which has held 18 sessions. It appears, however, that none of the 36 reports issued as of October 2024 explored the interrelationship between business activity and UCMs, as if the problem did not exist. The same applies to the yearly Forum on Business and Human Rights, which has held 12 sessions, each session packed with as many as 60 side events. The concept note for the 13th session of the Forum on Business and Human Rights does not make any reference to either sanctions or UCMs. It would be desirable that the FBIHR to integrate UCMs into the agenda and during the informal dialogues at the beginning of each session. The guiding principles do not mention the concept of unilateral coercive measures, not even the UN practice of imposing crippling economic sanctions under Chapter 7 of the UN Charter, or the infamous Security Council sanctions list promoted by the United States in the context of the first Gulf War and the so-called War on Terror in the 1990s and 2000s, although these UN sanctions resulted in 1 million deaths in Iraq and enormous human suffering. Although the guiding principles on business and human rights fail to make any reference to sanctions or UCMs as direct causes of gross violations of human rights, many of its provisions are relevant and should be understood as extending to UCMs. Indeed, the 3 preambular standards can be so interpreted. A, states existing obligations to respect, protect, and fulfill human rights and fundamental freedoms. B, the role of business enterprises as specialized organs of society performing specialized functions required to comply with all applicable laws and to respect human rights. C, the need for rights and obligations to be matched to appropriate and effective remedies when breached. As to the state's duty to protect human rights, principles 1 and 2 of the guiding principles should ensure that business enterprises do not cause human rights violations, including by implementing illegal UCMs. States should ensure that business enterprises do not become instruments of foreign powers by implementing extraterritorial legislation that has impacts on the territory of the states where they operate. Business enterprises should be held accountable for not incorporating into their business strategies and decisions the clear message of the yearly General Assembly resolutions that condemned UCMs as contrary to the UN Charter and international law. There is even a pending case before the International Criminal Court on the issue of whether UCMs constitute crimes against humanity within the meaning of Article 7 of the Statute of Rome. Business enterprises are therefore on notice that UCMs are illegal, even criminal. If necessary, it necessarily follows that by implementing UCMs, business enterprises assume both civil and penal liability for the harm caused. The general guiding principles, operative principles, lay down a general state regulatory and policy function. Principle 3 stipulates, I quote, in meeting their duty to protect, states should enforce laws that are aimed at or have the effect of requiring business enterprises to respect human rights and periodically to assess the adequacy of such laws and address any gaps. End of quote. It is for states to adopt appropriate legislation that prohibits business enterprises to implement illegal UCMs and ensure their compliance with domestic law. Alas, a serious normative gap exists because states have not yet adopted specific legislation prohibiting business enterprises from becoming instruments of foreign governments by implementing their illegal UCMs and consenting to the extraterritorial application of foreign legislation in violation of the state's sovereignty and exclusive jurisdiction. Absent any pertinent legislation, business enterprises tend to take the easy way out and bend under the foreign UCMs. This must be stopped, but then the state must reciprocate by committing to proactively defend its enterprises from penalties eventually levied upon them by the states imposing UCMs. Such protection can take the form of diplomatic protests and could be strengthened by declaring the ambassador of the country imposing UCMs persona non grata, pursuant to Article 9 of the Vienna Convention on Diplomatic Relations, by expelling other agents of the state imposing UCMs, and by elevating the dispute to the International Court of Justice or the Permanent Court of Arbitration. For instance, if because of UCMs, a private bank refuses to transfer or to receive monies from a country under UCMs, and that failure to perform the normal functions of the bank adversely affects the human rights of the population in targeted countries. For example, if money transfers to buy foods or medicines cannot be effected, then the bank is complicit in the famine and the death that may ensue. Many countries have, quote, persons in distress or duty to rescue legislation that obligates private persons to assist someone whose life may be in danger. Such legislation entails not only civil tort liability, but also criminal responsibility. Domestic law must oblige banks to perform their regular functions without discrimination and to reject any effort from a foreign country to interfere in the normal operation of financial transactions. Such interference constitutes a form of intimidation and blackmail that similarly must be prohibited by law as contrary to international ordre public. In civil law countries, duty to rescue legislation is quite common, e.g. in Belgium, where the obligation was introduced by the law of 6 January 1961, which stipulates that failure to provide assistance is punishable under Article 422 bis of the Penal Code. The conditions of the duty to relate to awareness of the hazard and the possibility of helping without putting oneself in physical danger. In the Canadian province of Quebec, the Charter of Rights provides for a general duty to rescue, quote, every human being whose life is in peril has a right to assistance. Every person must come to the aid of anyone whose life is in peril, either personally or calling for aid by giving him the necessary and immediate physical assistance, unless it involves danger to himself or a third person, or he has another valid reason, unquote. It should be stressed that states, wow, I'm already over? I'm already over. So you can read it later. Thank you.
Oh, I didn't expect. Sorry. Thank you very much, Alfred. Indeed, there are lots of issues to be discussed on the point. And now I'm giving the floor to Professor Joe Gordon, the Ignacio Elorricia Chair in Social Ethics in the Philosophy Department at Loyola University in Chicago. And she will discuss the topic of overview of overcompliance and risk assessment, and she's making her presentation online. So, Joe, the floor is yours.
Okay. So first, I would like to thank the Special Rapporteur, Professor Elena Duhan, for inviting me to speak at this important event. I also want to take this opportunity to acknowledge her leadership in articulating the many pressing issues related to unilateral coercive measures and their negative impact on human rights. Today, I will be talking about overcompliance as it has emerged from the practices of the U.S. Treasury Department's Office of Foreign